Good morning. Is everyone here? Good morning, Mrs. Khan. Mr. Kapoor, you're still under your affirmation to tell the truth, yes?
That's right. I agree.
Thank you. It's Mr. Vajani.
Thank you, Your Lordships. Morning, Kapoor.
Good morning, Mr. Vajani.
Kapoor, may I take you to the bundle H once again?
What page?
858.
858.
528.
528.
Yes. Mr. Kapoor, may I request you to mute until you're responding, because then there's a lot of echo. Thank you.
Mr. Vajani, it's H538 or 28.
528. 28.
Yes, I'm there.
I saw your lips move, Mr. Vajani, but I think you're muted.
My apologies. Mr. Kapoor, is this document to be identified as a mortgage over movable properties dated 30th of December 2018?
That's correct.
Mr. Kapoor, if you go down to the next page, is 859.
529.
529.
Yeah, sorry.
Yes, Mr. Vajani, I'm there.
The first recital. May I request you to read the first recital?
Yeah. Read it to myself or you want to
Read
read?
it yourself, please. Read it to yourself.
Right. I've done that.
It's correct that this agreement is in continuation to the facilities agreement dated 25th of November 2017,
Yes.
and it covers all the facilities that were granted, availed by you under the facilities agreement dated 25th November 2017.
Yes.
At the bottom of the page, does it bear the initials of yourself and Mr. Ravi Kuchimani, which is defendant number 5?
That's right.
Would you identify your initials and D5's initials at pages H530 to H534?
That's correct.
May I now request you to see H535.
That's right.
Does that bear your signature
Yes,
on behalf of D1?
that's correct.
Does that bear the signatures of D5 on behalf of D1?
That's correct.
Mr. Kapoor, where did you sign this document?
I don't recollect exactly where we signed it, but usual practice was to go to the bank's branch and to sign there.
Mr. Kapoor, could you confirm that the initials on the next two pages, which is H536 and H537, are the initials of yourself and D5?
Yes, that is correct.
Mr. Kapoor, could you explain why this agreement was signed on 30th of December 2018?
I don't recollect why it was signed, but the purpose was to create a mortgage on the movable property, which is the plant and machinery. Well, I'm not sure why you're asking the question as on that date, but I know what is written in the agreement is to create a mortgage on the assets.
I'll rephrase my question. My question meant, what I meant by my question was that why was it signed in December of 2018?
Don't recollect why this was signed then, but maybe the bank requested us saying that they needed to get the sign and they must have signed it. Look, I cannot recollect any specific instance why it was signed in December of 2018.
Is it correct to suggest that this was signed since the facilities granted right from 2014 were being continued to be availed by D1?
Yeah, that is correct.
Thank you. May I now request you to go to the I bundle, please?
Yes, please.
And if you may go to I3087.
3487.
3087, your lordships. 3087.
Three four eight seven
3087.
3087. Yes, I am there. 3087.
Is this document to be identified as a utilization notice under the facility agreements which was signed by you from time to time from 2014?
That is correct.
Does this utilization notice bear your signature?
That is correct.
Does the utilization notice bear the signature of D5?
That's right.
Was this signed by you in original?
I cannot recollect that, but I'm sure I might have. It's an event which was long time back.
I put to you, Mr. Kapoor, that this was signed by you in original and given to the bank, and the same is available for inspection with the counsel of the claimant.
Yep.
Is that correct? Are we in agreement?
Yes, I mean, I'm not denying this is not my signature, but I'm saying I don't recollect whether I signed it in original or I delivered it, to my office and then they delivered it. That's what I'm saying. So I'm not disputing it's my signature.
That's right. Thank you. Mr. Kapoor, could you also see pages 3088, 3089, 3090, and 3091, and identify that the same have been signed by yourself and D5?
That is correct.
Mr. Kapoor, could you confirm that this transaction was honored by the bank?
That is correct.
And you also confirm that these funds, as requested for utilization, were made available in the account of D1 for payment to the supplier of D1?
That is correct.
Kapoor, could you go to I3094?
Yes, I'm there.
Is this a letter addressed by you to the claimant on behalf of D1?
That is correct.
And is the signature on I3095 yours?
That is right.
Thank you. Kapoor, you go I3096.
Yes, I'm there.
Could you identify? Sorry, mute. Mr. Kapoor.
Yes, I can hear you.
No, if you could mute, it's coming back as echo.
Mr. Kapoor, I get a blowback on the echo if you're not muted, so you can try and remember each time. Thank you.
Thank you, Mr. Kapoor. Thank you, Lordship. Mr. Kapoor, are you on I3006, 3096?
That's correct.
Lordships has that?
Yes.
Mr. Kapoor, could you identify who is Akash at velocityglobal.in?
He was heading the finance function. He was group manager finance, group general manager finance.
Could you also identify who is Komal at velocityglobal.in?
Komal was another chartered accountant reporting to Mr. Akash, working for Velocity.
could you confirm that usually the email correspondences on behalf of D1 with the claimant were done by Akash and or Komal?
That is right. In fact, under Akash or apart from Komal, there were other people in the finance team as well. So it would always be with the finance team. And in case there was something important, then it would be also marked to me and Ravi.
Could you repeat the last part of your answer, please?
I said if there was an urgent matter, then it would used to also get marked to me and Ravi.
By Akash, Komal, and their team.
No, by the bank.
I will ask the question again. That usually when there was a communication from D1 to the same would also be addressed by Akash and or Komal.
That is correct. Because they were managing the finance team.
Yes, Mr. Shaheen.
It is the mouse movement which is creating the noise. When Mr. Kapoor is touching the mouse, which is probably next to the mic, and that is creating the noise, the echo sound.
I see. Are you touching the mouse, Mr. Kapoor, from time to time?
I'm touching the mouse now since you've told me to mute when I'm not speaking to avoid any noise at your end. Otherwise, there's no need for me to. In fact, I'm at a place where because of the storm which we had, there is no power. So maybe there is a ceiling fan which may be causing that noise.
Right. Anyway, okay, we'll see how we go on. Thank you.
On a lighter note, I got a little worried that Mr. Shaheen was objecting my questioning Mr. Kapoor also.
I'm sure it wouldn't happen. Right.
Thank you.
Mr. Bajani, you got my answer. Is that
That's right.
okay?
That's right.
Yeah.
You repeated your last answer to say that the correspondence which would be addressed from D1 to the bank would generally be addressed through the emails of Akash and/or Komal or their finance team, and we're agreed on that position.
That's correct.
Mr. Kapoor, may I now then request you to go to I3160.
Yes, I'm there.
Is this another utilization request addressed to the bank?
That is correct.
Does it bear your signature?
That is correct.
I put to you that this was done in continuation of the facility agreement dated 25th November 2017.
That is correct.
Does it also bear the signatures of D5?
That is correct.
Does it also have some endorsement made by D5?
Yes, it has.
Could you also confirm the signatures on I3161, including the endorsement, and the signatures on I3162, including the endorsement?
That is correct.
Could you also confirm your signatures and the signature of your signatures on I-3163 and I-3164,
That's correct.
and the signatures of yourself and D5 on I-3165.
That's correct.
Is it correct that the bank accepted the endorsement made by D5 and only US dollars 90,000 were released in the bank account of D1 for being paid to the supplier of D1?
That's correct.
Is it correct that this utilization notice was honored only to the extent of US dollars 90,000 and no more?
That's correct.
Mr. Kapoor, now if you can go to I 180.
Yeah. Could you just give me a minute, please? I'm just making a note.
What page was that, Mr.
3183, Lordships. 3183.
Are you referring to 3168?
80.
3180. Yes.
Is this also a utilization request and notice which was sent by you on behalf of D1 to the bank?
That is correct.
Does it bear the signatures of yourself and D5?
That's right.
Could you also confirm the signatures on I-3181 and 3182 to be the signatures of D5 and yourself?
That is correct.
Could you also confirm your initials on I-3183 and I-3184?
That's correct.
You also confirm the signatures of D5 and yourself on I-3185.
That's correct.
Was this transaction also honored by the bank as requested by D1?
That is correct.
Mr. Kapoor, I once again put to you that even on 18th April 2019, the transaction were being honored in accordance with the facilities advanced to you, that is D1, guaranteed by all the personal guarantors under the facility agreement signed from 2014 and time to time.
Under the facility agreement, yes, but as far as the events are concerned, on this date, let me just check the date. We're talking about April 2019.
Yes.
We had communicated to the bank the amended memorandum and articles of association. So I'm not sure whether the change of shareholding was still in the bank's mind, the old one or the new one, as I had already examined Mr. Maniram yesterday.
Mr. Kapoor, my question was very different. My question was that this facility was availed by you as per the limits granted right from 2014 and continued from time to time right up to April 2019.
Right.
Is that correct?
Yeah, that is correct.
Mr. Kapoor, may I request you to go to I3189.
Could you repeat that, please?
I3189.
I'm there.
Is this also a utilization request?
That is correct.
And this is dated 20th of May 2019.
Yes.
Just bear your signature
That's right.
to identify your initials on I3190 and I3191.
That is correct.
Could you also verify your signature on I3192
That is correct.
and I3194
That is correct.
and I3196?
That is correct.
Is it correct that this transaction was to the same entity who was your supplier in the previous two transactions?
That is correct.
Is this transaction for 620,000 US dollars?
That is correct.
Was this transaction honored by the bank as requested by you?
That is correct.
Was any objection received by anybody for this transaction after the same was honored?
Not to my knowledge.
Mr. Kapoor, I put to you that the last four PR requests or utilizations which I showed to you, being I3087 to I3093, I3160 to I3167, I3180 to I3187, I3189 to I3196 were duly honored by the bank as requested by D1.
That is correct.
I put to you that the same were honored in continuation of the facilities advanced and renewed from time to time since 2014.
That is correct.
I put to you that these last four transactions went into default.
That is correct.
Mr. Kapoor, may I now request you to go to I3238, 3238. Sorry, I228.
228.
228. My apologies. 28, not 38. 20.
That's all right. You can say the whole thing again then. 3228.
That's right, sir.
Give me. Yeah.
Mr. Kapoor, are you ready?
Yeah, I'm just reaching the document, scrolling down. I-3228.
That's right.
Yeah.
Could you identify this document for me, please?
This is a recall notice issued by the Union Bank.
Dated 3rd of September 2019.
That is correct.
Is it addressed to yourself?
That is correct.
Did you reply to this recall notice?
No.
Mr. Kapoor, you had at the start of your cross-examination mentioned about your experience as a banker.
Right.
In your experience as a banker, as I understand over decades, how many restructurings have you been involved in?
Restructurings as in
Restructurings of the borrowings of those banks, borrowings of the borrowers of those banks you were working for.
Not too many, in fact. I mean, essentially my area of expertise was the capital markets and managing stock markets and a lot of other things, but not direct lending facilities.
In your experience, limited as may be as a banker, as you say, on the
Right.
retail side or the borrowing side, how many instances has the bank made a proposal for restructuring?
The bank and the client normally have a discussion regarding the issues, and then suggestions are made by the banker based on their policy, and suggestions are made by the the borrower based on their current position and what they see happening, and out of that is what a proposal emerges.
Mr. Kapoor, I put to you that there was no proposal made by D1 for restructuring of any of its facilities.
That is incorrect.
Kapoor, could you show me any document from the bundle which would be a restructuring of the default that is committed by D1?
So, Vichari, we just went through a document where I had discussed with the bank the restructuring of the working capital limits without enhancement. That was at the time when I had gone and submitted an agreement which we had signed with a potential new customer. And I yesterday asked that question from Mr. Maniram that why he did not have it on record. Because most of the interaction of this nature, where anything has to be done, any new developments are there, were always in person, face to face. You go to the bank, you sit there, explain to them, explain your needs, you explain the new working capital cycle required, and they said, this is the solution, why don't you give us a request in writing? So that was given and the agreement was shared.
May I take you back to the same letter again, Mr. Kapoor?
Yes, please. What is the reference number, if you can tell me?
I'll just give it to you. Give me half a minute. I-3094.
Right, I'm there.
Mr. Kapoor, I put to you that this is not a communication for restructuring of defaults, but is only a communication for rearranging the existing limits granted by the bank.
Yeah, see, at that point of time in December, we're not talking about defaults. There were not defaults there. I mean, basically, there were some delays, and we had discussed that here onwards we need to move on and start this new business. In fact, I remember clearly that I had made a presentation or explained to the about the whole business cycle. We had even taken some sample of products to the bank branch, and that is when they themselves suggested that right now you cannot look for an enhancement. In fact, let me explain. The total business we were seeking with that customer was around 21 million or 22 million dollars, right? If you see the current limits, which are only $6 million, would not have been sufficient to meet that need. So we actually explained that need. The bank said at this juncture, we will not be able to request any enhancements. So then when I explained that these are some premium products, these are glass bottles which have a long gestation period to arrive, etc., and your LTR limits are, let's say, 120 days, we will end up defaulting on those LTR payments. So the suggestion was made that if you make a request to structure half the facility as an overdraft, which is obviously a continuing utilization, which does not have a timeline, you can get started with this business. When you start this off, then we will be able to go back and seek an enhancement after a few utilizations. This was the entire summary of the discussion.
Mr. Kapoor, I put to you that all that you have just said is not available by way of any witness statement or documentary evidence on the record of this court.
Well, I can definitely look for some evidence. If I can find it in an email, I'll be very happy to submit it again as a part of my closing arguments. But the usual practice with the bank was that whenever there was anything new happening, either me and Ravi or along with the finance team, we used to go and sit face to face with the bank. In fact, in this meeting only, I had advised them of the change in shareholding. In the same meeting, I had explained to them that a new fund, which is called Adivat, who is already an investor in a group company, is looking at taking a position in this business. So it was a very long discussion. In fact, only after submission of this letter and that in principle discussion did we actually go and sign the agreement with the multinational 3 weeks later.
Mr. Kapoor, what prevented you from recording what you have just said in this letter itself?
Because this letter was for the limited purpose of, sorry.
Mr. Kapoor, I just want to make sure I understood the question. I missed the end of it.
Sorry, Your Lordship. Mr. Kapoor, would you please mute yourself so that I can be clear? Mr. Kapoor, yes, Your Lordships. I asked Mr. Kapoor a question as to what prevented Mr. Kapoor from recording what he is just saying in this letter itself.
Mr. Kapoor.
Yeah. As I explained, the normal practice was to go and meet with the bankers, make the presentation. As I explained here, we went even with the samples of the products, and we actually made a presentation. We explained the working capital cycle, and the only request from the bank was, please submit a request to just restructure the nature of the facility without seeking any enhancements. So we just justify why you need an overdraft limit and not a pure LTR facility. That was the request from the bank. So that's why this specific letter was issued for that purpose.
Kapoor, your letter does not suggest anything that you have just stated.
Because this letter is being looked at in isolation. If you read this letter along with the agreement copy which I had submitted, it will be absolutely clear. And now the bank is claiming that they never got that agreement in fact, which I have reiterated in my submissions when I went to Mumbai. When this default started happening, and I explained to them, look, there is a curing period. If you can give us an opportunity even now, that contract can be activated and we can still save this business. Which mysteriously, after acknowledging in writing that they received that letter was not even submitted to the branch.
Mr. Kapoor, have you put anything that you are saying or by way of oral evidence now on record by way of your witness statement or documentary evidence?
I'll have to just check my witness statement. I cannot, say offhand, because I must have definitely mentioned that we had this agreement and we had this business opportunity. I'll have to look for a reference in my witness statement. I can't recollect offhand.
Mr. Kapoor, I put to you that there is nothing in your witness statement nor any documentary evidence on record suggesting what you have just stated.
I cannot confirm or deny. I'll have to check.
Well, you'll have the opportunity later if you want to come back to that, Mr. Kapoor, rather than us spend 3/4 of an hour while you go through every statement. You'll have the opportunity when in re-examination or in submissions.
Yes, I will. I will, Your Honor. I will definitely put all the evidence, because I'm actually surprised that the bank did not have it on record. I mean, this was even when I discussed in Mumbai with the people I met. Even they were aware that yes, this agreement is there, this is possible, but essentially there was no action.
Mr. Kapoor, did you ever receive any no objection from the bank for all the transactions that you have now been orally suggesting?
No objection?
From the bank?
Why would I need a no objection from the bank?
Mr. Kapoor, I put to you that all your facility agreements mandate seeking a no objection from the claimant prior to any change that you are suggesting.
I'm not understanding this. Sorry, it's my fault.
I'm not clear with what you're asking.
Mr. Kapoor was suggesting changes in the company as well as its business. All of that require a no objection from the bank. So I was asking him, did he get any no objection from the bank for the changes that he was just suggesting?
That's it. Mr. Vajani, that is what I stated. We made them aware of the potential changes. We made them aware of the notarized agreement. We made them aware of the new business opportunity. And at that point of time, the bank did not say to me that you need an NOC from us or anything like that. They simply said, please submit this letter for restructuring the facilities so that you can get on with this business. And if you remember, Mr. Maniram himself said that this is December 2018, right? And he said that December 2018, they were anyway going to go for a process of the annual renewal process. And anything like this would have been covered in that.
Mr. Kapoor, I once again put to you that neither this letter nor the renewal letter dated 5th January 2019 circulated by the claimant, which is at I-3106, reflects the oral statements that you are now making on record.
Mr. Vajani, this is the first time I'm hearing about an NOC. And when you deal with a banker where you deal...
Mr. Kapoor, first answer my question. You may then explain that I have put to you that your letter as well as the bank's renewal sanction letter dated 5th of January 2019 do not reflect any of this which you are now orally trying to state.
Yes, they do not reflect, and that is one of the reasons why we did not sign and acknowledge it. Because it was done unilaterally, reductions of the limits were done unilaterally, despite all this information and opportunity being placed in front of them.
Did you respond to the 5th January 2019 sanction letter?
We went to the bank, we spoke to them and said, this is not correct. Why are you reducing our limits? We again had a verbal discussion. the process with the bank has not been to write letters at every stage. The process with the bank has been to go meet in person and discuss to find solutions.
Mr. Kapoor, after the recall notice, did you write any letter seeking a meeting with the bank?
Mr. Vajani, I humbly submit that there was no need for a letter. We actually went to the bank and met them to discuss the issue. Because this was not the common practice at all. In fact, if you ask the bank to produce any number of letters which we have written to them on a regular basis, I would understand that this was normal practice. The normal practice was to go and meet them and sit with the CEO, with all the responsible people and discuss the issue, so that whatever suggestions came out is only those would be recorded or would be sent in writing.
Mr. Kapoor, I don't want to take more time, since we also have
Yes,
to now break at 1. I put to you that none of the so-called discussions or meetings that you are now stating that have been initiated by yourself on behalf of D1 have been recorded or reflected either in your written statement or by way of your witness statement or by way of your documentary evidence.
Mr. Vajani, I am actually equally surprised that the bank is denying any knowledge of this contract or any such discussion. There was no written letter, I can understand, but that was never the normal practice. In fact, I would ask the bank to review their relationship with us from 2014 and produce the number of letters we have written to them. If the process you defined were to be followed, there would have been hundreds of letters.
Mr. Kapoor, I also put to you that in your experience as a banker, there was no request for a meeting made by either yourself or any of the defendants seeking bank's intervention with the other stakeholders after a series of defaults over 15 months and the recall notice.
Mr. Vajani, this question cannot be answered in isolation.
First, yes or no, and then you may explain. I have no problem.
So could you repeat the question?
My question is that there was no request made by either yourself or any of the defendants calling for the intervention of the bank during the 15 months of continuing default until the declaration of the NPA or the recall notice or even thereafter.
No, there was no written request. And now can I explain?
Of course.
Yeah. So there were always meetings, and as my experience as a banker, most bankers maintain a diary note. They record what was discussed with the client. They put the documents submitted into a client file, and only when a specific legal requirement comes up by like enhancement or change, etc., the bank requests you to put a request in writing, and that has been the practice with Union Bank throughout our experience.
Thank you, Mr. Kapoor. Your Lordships, I have no further questions.
Thank you, Your Honor.
Yes, thank you. Mr. Shaheen, it's your turn, I think.
Yes, Your Lordship, we just have 11 minutes before my requested break for the prayer. So
Of course.
how does the Lordship want to go?
Well, do you want to deal with any short points? And then we can break.
Yes, Your
Well,
Lordship, so that we don't lose time. I'll do.
we'll stop in 5 minutes. So.
Yes, Your Lordship. 1 o'clock is okay. Mr.
We'll
Kapoor?
stop just before 1 o'clock.
Mr. Kapoor, am I audible?
Yes, Mr. Shaheen, I can hear you well.
Good afternoon.
Good afternoon to you.
Where are you now?
I'm in New Delhi, India.
Have you taken any special permission from the government of India to give evidence in this case?
No, I haven't.
You have not. What is your address in New Delhi?
Your Honor, I'd like to seek a clarification. Am I obliged to answer that question or provide that information?
Oh, you've given your address in a witness statement, haven't you?
Your Lordship, if I may clarify the purpose of my question, the body of the statement 29.24, according to the RDC, the witness statement must, if practicable, be in the intended witness's own words, and the witness statement should be expressed in the first person and should also state, 1, the full name of the witness, 2, his place of residence, or if he's making a statement in his professional business, that goes. So the place of residence, which means the address to me. That's why I'm asking this question.
What is your objection, Mr. Kapoor, to giving your?
No, the clarification I seek from your Lordship is that I am stating that I am in New Delhi, India, and I'm appearing in person. So am I obligated to give a physical address?
Unless you have a valid reason for not giving your address, then you are required by the rules to give your address.
Well, the valid reason is simply the disputes which have been going on between D4 and D5, and a lot of these ex-party orders and other things which I just came aware of during the course of the proceedings. And I'm still seeking legal advice in terms of how to go and represent myself on those cases. So I do not, want to just volunteer information if I'm not obligated.
Well, you are required to give your address unless there is a valid reason. Simply because you don't want to give your address is not a valid reason. If you have safety concerns or something of that sort, then that would be a valid reason. But is there any valid reason?
Well, as far as currently the situation is concerned, since the counsel for D2 and D5, Mr. Shaheen, has mentioned that my immigration status in their UAE record still shows as since I am in UAE. So it definitely is something which is very perplexing, and it does raise some safety issues that tomorrow some criminal action or something else may be initiated against me. So it is in that context that I would like to seek this clarification from your Lordship.
The position is this, that it cannot be a good reason for not giving your address that you want to avoid legal action. If there was a different matter, if your physical safety was endangered or something of that sort, but you're not suggesting that, so you must give your address, please.
All right, then I'll state the address. That's fine. The address is B for Bombay, 334 New Friends Colony, New Delhi.
Is Mr. Shaheen?
Yes, Your Lordship, I can continue. Your first witness statement does not contain a date. Your first witness statement does not contain a date.
So is that a statement or is that a question?
Is that right or not?
Yesterday when I went through all the witness statement, we did find that it did not have a date.
You could give it a date answer. Now, the 9th witness statement which you call, which is dated 27/5/2022. Is it the 9th?
That's not the 9th. What page are you on, Mr. Shaheen?
1 second, Your Lordship. The 9th one.
9th is G357.
G357. You have not referred to it as a witness statement, but you have called it reply to second witness statement, Anjali Sivaramakrishnan. It's a reply, it's not a witness statement.
Is that addressed to me or to the witness or what?
To the witness, I'm asking him. He calls it a witness statement.
No,
but
Mr. Shaheen, to be fair, I called it a witness statement. I was simply trying to adopt a common terminology to identify the documents Mr. Kapoor sets out his case in. I'm the one that said witness statement.
Apologies, Your Lordship, but we can correct it if we want, because it's called a reply statement, reply to second witness statement. It's not called.
I don't propose to correct it at all. It seems to me, whether it's called a reply or whatever, it sets out part of Mr. Kapoor's case, and that's a witness statement.
Yes, Your Lordship, I go by that.
Anyway,
Now,
sorry, carry on.
Mr. Kapoor, you're a strong believer in God. Am I right?
I can say that.
Why did you prefer an affirmation against an oath?
Simply because my understanding was that taking an oath would have required the physical presence of a holy book in my hand. And I am not in possession of a holy book at this point.
You knew that possession of a holy book is required, right?
Because I learned that during the course of this proceedings, as I'm sure yourself and your honor would acknowledge that I'm not a lawyer. I do not have any legal background. So I know that during the course of this proceedings, it was offered to somebody that will you be taking an affirmation or an oath? And there the difference became clear. So that is why I took the affirmation, because I don't have a holy book here right now in my hand.
What if I say you deliberately avoided an oath, knowing the nature of statements that you're going to make afterwards?
I deny any such allegations.
Oh.
Mr. Shaheen, it's now 2 minutes to 1 o'clock. Would you like to stop for, is it half an hour?
One question and I will stop.
Okay, one question.
When did you leave UAE?
I left in somewhere in August, end or beginning of September 2019.
End of August or beginning of September 2019.
That is correct.
Yes, Your Lordship, now we can take a small break.
When should we resume? At half past?
1:40, if you honor, allow me. Suppose I take a 2 minutes extra to come back from the place.
1:40.
1:40, Your Lordship.
Very well. We'll adjourn for 30 minutes. 40. Mr. Kapoor, you're interrupting your evidence. Don't talk to anyone else about the case in the meantime, please. Thank you.
Thank you.
Much obliged, Your Lordship.
No, we are ready to begin, Judge.
Yeah, thank you. Yes, well, Mr. Shaheen, Mr. Kapoor, you're ready to resume.
Very good afternoon, everybody, and thank you very much for accommodating my request for 40 minutes break. Thank you all.
Not at all.
Mr. Kapoor, you said you left UAE in 2019, end of August or beginning of September. Am I right?
That's right.
You had a criminal case pending against you during that period.
Not aware. I mean, basically, there was no, it was not in my knowledge.
The case number was 3837 of 2019, if I may remind you. A criminal case number before the Ras Al Khaimah Public Prosecution Department, criminal case number 3837 of 2019. Am I right? Or you don't remember?
No, I don't remember. In fact, a lot of these cases I came to know only during the proceedings and your submissions.
You were taken to the public prosecutor's office for questioning.
Taken to the public office?
You were taken to the public prosecutor's office in Ras Al Khaimah for questioning. You can say yes or no.
I don't think I was taken to any office for any questioning.
You went to Ras Al Khaimah Public Prosecutor's Office for questioning.
No, I went to the public prosecutor's office to seek some clarifications about some complaints I had heard about having been filed.
Okay. Your passport was kept there. They took your passport from you and gave you a receipt.
I don't recollect.
You don't recollect. I say your passport is still there at the public prosecutor's office in Ras Al Khaimah.
No, that is incorrect. The passport is with me.
How did you leave UAE?
I traveled as normal. I mean, I went for a visit to Oman, and then from there I flew to India.
Can you, if I challenge you, will you be able to show me a stamp on your passport from the UAE immigration authorities?
Yes, there is a stamp in my passport from the UAE immigration authorities.
Can you produce it before this honorable court?
Yes, I will send it off later. I mean, I don't have that passport with me right now.
Very good. Is your residence visa in UAE still valid?
No, it is not.
After August 2019, August or September 2019, as you said it, you have never visited UAE.
No, never.
You have never visited any of the GCC countries too.
No.
You had various business interests in this region during that period when you left this place. You were a partner in many companies.
In this region, are you specifically talking about the GCC or you're talking about only UAE?
Can be UAE, it can be GCC also. You had business interest, partnership in various companies in UAE.
In UAE, yes.
Yes.
But not in the GCC.
Your Emirates ID number 784 1966 704 10602. Is that correct?
I cannot recollect my Emirates ID number.
Do you have it with you? You are sitting in front of your system, you can verify.
I don't have it in my system. This is my laptop, which I'm using for deposing before you. But I mean, if you read out a number, how can I verify it? I don't have it with me.
Okay, fine. Are you still using the same passport on which you traveled from UAE last?
That is correct.
You're still using the same passport.
That's right.
The passport number is same.
Yes.
What is that passport number? Can you recollect?
I don't remember the passport number.
And you don't have a copy or anything in your mobile phone or the laptop in front of you?
No.
No. What's your full name?
Vijay Kapoor.
Your father's name?
Ramesh Kapoor.
So if I add the father's name to your name, which is a normal practice in UAE authorities here, your name will read as Vijay Kapoor Ramesh Kapoor. Am I right?
I have no knowledge of that. I mean, if that's what it happens there, but essentially I know my name, I know my father's name, but I wouldn't know how it would be referred to in UAE.
How was your name written in your Emirates ID?
I don't recollect because I don't have it in front of me.
Okay. How was your name written in the residence visa of UAE?
Because I mean, you don't look at your residence visa every day. I mean, it's something which happens once in 2 or 3 years.
Okay. So whatever happened before 3 years, you don't remember?
No, it depends on what is it that I need to remember or what is important to me for my things. And it's not like I will forget everything or I'll remember everything.
I will put it in a different way. If you want to remember something, you have to look at it every day. Your statement, I'm asking you.
No, that
It's
is
very
not
important for me because you had made very big revelations about whatever happened during the period 2014 to 2019. You remembered everything of that, but you don't remember your own passport number, or you don't remember how your name was written in your residence visa or your Emirates ID.
Mr. Shaheen, these are two different things. When it talks about business, what happened, certain events, you remember them because they are important and they happened. These are things which you can easily refer to when you need the document and open it and look at it. So why do you need to memorize it anyway?
Can you refer it to now? Open and refer it to now.
Which is what I just said. I don't have it here with me. I'm sitting at a different place in an office where I'm deposing before you. So I don't have it in front of me.
So it's not easy today.
No, it's not possible today.
So you mentioned in the paragraph number 1 of your first witness statement, the last few words in the first page, G118.
Can I just open the statement, please?
Please, sir.
G118.
Yes.
Which page?
First page, last few words, in the regular course of carrying on its business. When you say in the regular course of carrying on its business, you mean your business. Am I right? You can read the full sentence for yourself. Paragraph number 1, the 3 lines, you can read it for yourself. And you can tell me the words in the regular course of carrying on its business there means your business.
No, it does not need my business. We're talking about D1 here, which is how can it be my business? It's the company's business.
Records maintained by the defendant in the regular course of carrying on his business means the company's business, not your business.
That is correct.
That's correct. So what is your business now?
My business now?
Yes.
I'm just a consultant.
Consultant for what?
For any kind of advice which I find I can give to my clients.
Any kind of advice.
Yeah, could be management related, could be marketing related, could be finance related.
Have you issued any power of attorney in favor of your lawyer, Ibrahim Al-Banna Advocates and Legal Consultants?
Yes, I remember that was issued, but that was some time ago.
Some time ago means when?
I don't recollect the exact date.
Which year?
This was. I'll have to look it up. I can't remember offhand.
How many years back? Approximately.
Should be about around 2017, 18, or I don't know, maybe 19. I'm not sure.
Anyway, while you were in UAE.
That's correct.
That's correct. Are you aware now, at least after this trial, that there are plenty of criminal cases and civil cases against you? The documents have been produced before the court.
Yes, I am waiting to go through those documents, as some of the documents have only been placed yesterday. So I heard references on those cases in some of the statements which I heard, but I have not seen the documents as yet fully.
Were you aware of the criminal case and civil case before D5 disclosed all those cases to this honorable court?
Except for the civil case in Fujairah, I am not aware of any other matters.
Your letter of engagement with Kochar and Company, which was much before the beginning of this case, and while you were in UAE, it referred to civil case and criminal case. Am I right? You have produced those documents, VK1, VK2, and VK3.
We have at that time there were no criminal cases, there were complaints. So I do not know whether a complaint and when it becomes a case. So I did apprise them that there are some complaints, and it was they who were supposed to verify it and find out what's going on.
Those complaints were to the police and the public prosecutor. You know that, right?
I have no idea.
You have no idea. Do you know how a criminal case is initiated?
No.
No idea. Now, D5 has produced a document which is now uploaded to the case bundle as K895.
K895.
K for kite.
Yes, I can see this.
This is an Arabic document and its translation. Correct?
It looks like an email to me.
It just looked like a lot of emails.
After the image, you come to, this is how we lose time. K910. K910 to K914 is an Arabic document. Am I right?
I'm just getting to that place. K910.
Yes. To K914 is an Arabic document.
What I see is an English document.
K910 to K911.
Okay. K911 is an Arabic document, yes.
Now, K898 to K909 is from the translator, Arab American Translation Center. Am I right?
It's a translation of which document?
It's a translation. That's all I said.
Okay.
Okay. I know you will ask that question. That's why. And the translation shows in the middle column on the top, citizenship and residence systems, persons information report.
Right.
The date is on the right column, 2/6/2022. Yesterday, right?
Okay.
Okay. Okay, fine. Now on the left column, it shows Federal Authority for Identity, Citizenship, Customs, and Port Security. Right?
Yep.
Fifth item below that shows the name, Vijay Kapoor, Ramesh Kapoor.
That's
Is that
correct.
your name?
That is correct.
That's correct. The row above that, ID number 784-1966 704-10602. Am I right?
Yeah.
The row just above that, person's status inside the state. Correct?
That is correct.
Do you have any explanation for this? Your status is shown inside UAE as of yesterday, and you say you left UAE in August 2019. You never came here. You're still in India. What is your explanation?
How can I explain anything about a system which is there in the UAE? When I exited the country, I got an exit stamp. So how am I supposed to check the system on behalf of the immigration authorities when I leave?
That's your explanation.
That is correct.
I say you left UAE by illegal means when your passport was kept with the Ras Al Khaimah Prosecution Department, and that is why the system still shows you are in UAE. You are unable to return to UAE. Right or wrong?
That is incorrect because my passport is with me and I left legally.
Any particular reason you did not come back to UAE after 2019?
2 years of Corona.
That started in
Everybody,
March.
that's correct. And thereafter, for personal reasons, because my father-in-law expired, I had to take care of a lot of things. So I've not had any reason to come back to the UAE.
You did not have any reason to come back. What happened to all your businesses in UAE?
Those businesses were not just my businesses. Those were businesses which were again jointly with other investors or with other partners. So those other partners are looking after and running those businesses.
Those other partners are looking after and running those businesses. Are you getting your dividends?
No.
No. Any particular reason?
I mean, if the company is doing well and it is declaring a dividend, I will be intimate. If the company is not doing well, then I don't have any expectation of a dividend. So I have no idea what's happening with those companies.
Can you name 2 or 3 of those businesses?
Velocity Foods and Beverages, which is in Fujairah,
Okay.
and Velocity International Logistics.
Okay. Only 2. You name one. You want to name one more?
There is no other business.
There's no other business. When did the disputes with D5 start?
There's no actual date for this, but it was sometime in 2018, middle of 2018.
Middle of
Around. That's what I recollect.
The recall notice was issued on 3rd September 2019. Am I right?
That is correct.
Your paragraph number 3 in your first witness statement says, second line, the facility was made available to the borrower from 1st April 2014 to 29th September 2019. Is that a typo? For 3rd September 2019, it was effectively recalled.
Yeah. Could you kindly give me the reference number of the document? Because I went ahead and the document.
119.
So what was your question, Mr. Shaheen?
Yes, Your Lordship. He has mentioned that facility was made available to the borrower from 1st April 2014 to 29th September 2019. Whereas
That's not what he says. He's saying that that's what the claimant says.
he didn't say anything, Your Lord.
In the statement you're reading from.
I'm reading from his statement.
Yes, I'm reading too, and it doesn't say what you say. It says the claimant stated the facility was made available to 29th September.
Yes, Your Lordship, you're right. I read it as a standalone sentence for the second line. Sorry for that.
It's always important to get all.
Sure, Your Lordship. Thank you very much. And the recall notice was 3rd September 2019.
That is correct.
So what do you say about claimant's statement that the facility was made available to the borrower from 1st April 2014 to 29 September 2019. Is it possible?
Yeah, this is a statement which is talking about the period for the facility as it gets renewed every year.
When was the last renewal?
It was sometime in January 2019. I think beginning of
January 2019. The sanction letter, January 2019. Was it accepted by any of the defendants?
No.
So can we consider it as a renewal?
So we cannot consider it as a renewal because it was not signed off by any of the borrowers or the guarantors. But effectively, the past practice had been that facility gets renewed and you still continue to use it. The only reason why we didn't sign that is because we saw that limits had been reduced.
Okay. So when was the previous sanction letter that was issued, which was signed and accepted by everybody?
2017.
2017. Is it correct if I say that that sanction letter says the expiry date or the renewal date is 30th May 2018?
That is correct because we went through that during your cross examinations and other consuls examinations as well.
Is it correct to say that?
Sorry, you're getting too fast. 30th May, what date, what year?
2018, Your Lordship.
Yeah, thank you.
So is it correct to say that on that date, 30th May 2018, the facility expired and there was no effective renewal after that?
Well, if you look at the facility agreement, technically, that is correct.
That's correct. Now, in the recall notice, paragraph 4, you are referring to clause 21.17 of the facility agreement clearly mentions the existence of a cure period.
Right.
Correct? Did
That
the
is correct.
recall notice include any cure period?
No, it did not.
Had the claimant given a cure period, would you have been in a position to resolve the issue?
Yes.
Yes.
If you refer to my earlier testimony, in December 2018 itself, we had approached the bank with the additional orders and everything else.
And after receiving the recall notice, did you personally approach the claimant in India, in their head office?
Yes, I did. I went to meet them after asking for appointments. I got an appointment in November and I visited them on that date.
How many times did you go there?
I think 2 or 3 times, but I think the first important meeting where I went and made the written submission was in November.
Was in November. Who was the person you met there?
Mr. Cherian
Okay.
and Mr. Qureshi.
Mr. Qureshi. Was Mr. Maniram informed of your visit to the head office?
In fact, I learnt about it in my cross-examination yesterday. He was not informed at all, and it was quite surprising. Yeah.
Do you know why the head office did not inform the concerned person at their DIFC branch? Any particular reason for that? No idea.
Sorry, no idea.
In paragraph number 7, G120,
Yes, please.
subclause 1 says that the retainership encompasses the velocity group, which includes the defendant number 1 and defendant number 2. VK1, exhibit VK1.
Yeah, I'm looking at it.
This is the retainership you signed with Kochar and Company.
That is correct.
This witness statement, which does not contain a date, you said was actually signed on 30th November 2020. Produced before this honorable court on 30th November 2020.
Yeah, that is correct.
That's correct.
If you can take the date of submission as the date of signing, then that is correct. It could be one or 2 days here or there possible.
That doesn't matter. November 2020. For the purpose of that retainership, the lawyer representing the claimant mentioned that you were dumping and bombarding them with documents. Did you produce a lot of documents for their review? Did you submit a lot of documents for their review at that time, signing the retainership agreement?
We had personal meetings in the beginning where we were given a list of documents. They asked for certain documents.
Okay.
And thereafter, as each meeting progressed, additional documents were sent to them.
They provided you with an opinion relating to the business activities and steps needed for Velocity Group. That's item number 2 under paragraph 7.
That's correct.
That's correct. During your cross-examination by the claimant's lawyer, you were taken through a lot of documents, identifying signature, identifying your position. If I say bulk of these documents were produced by you before Kochar and Company, most of those documents which were referred to you during the cross-examination by the claimant's lawyer are documents which you had given to Kochar and Company after signing the retainership with them.
The documents you're referring to are the legal documents which I deposed for in the morning today?
Yes, most of those documents which you were confirming your signature or disputing your signature or whatever, most of those documents which were referred to you during the cross-examination by the claimant's lawyer were documents you provided to Kochar and Company.
We did provide them with the details of all the companies and their borrowings and documents relating to it. But I cannot say here under my testimony that exactly those documents, or obviously there were a lot of documents which are relating to the borrowing which were provided, just to explain to them what is going on, what are the total outstandings, where the company is, how we should be able to turn it around, otherwise we'll get into trouble, all that.
You disclosed the financial position of the company to Kochar and Company during that period.
I think as far as the financial positions are concerned, there were some audited balance sheets which were given specifically for the handling of the complaint. There were also financial positions of what the borrowings are and what is the upcoming installments and things like that, because that is what was also then later on discussed at the time of the settlement which we discussed with you.
Did those documents contain information and documents more than what you would have given back the claimant herein?
You broke up in the middle with the microphone. So could you try again, please?
Yes, sorry. Did the documents you gave to Kochar and Company contain your confidential information which you would not have otherwise given to the bank?
That is correct.
Do you think that such information, confidential information and documents you provided has left you in a disadvantageous position in this trial?
That is correct. In fact, that is why I had raised the issue of conflict in the first witness statement itself.
Okay. The first witness statement submitted in November 2020, you explained the conflict of interest.
That is right. In fact, that is the paragraphs you are referring to right now.
Yes. And such prejudice, which is caused, which you said is existing even now, is affecting the rights of D2 and D1 as well in this trial.
Absolutely right.
Item number 4 under paragraph 7.
Yes.
You are referring to an email dated 2nd October 2019 from Ms. Anjali Shivaramakrishnan to you at your personal email ID, wherein she has attached the updated strategy document.
That is correct.
The companies covered are again defendant numbers 1 and 2.
That's correct.
The copy of the email is attached as VK4 when you submitted your first witness statement.
That's right.
Do we
Can
have
you
the do we have the reference in the trial bundle to that?
Here it is exhibit VK4.
I know. How do I find that in the trial bundle?
Can I take a few seconds here?
Yes,
It don't take time now, but later on, can someone give me a cross-reference to these?
Yes, Your Lordship. I'll go to the next question, but I will submit the reference number shortly.
Just if someone gives me a list of the VK references and where they are to be found.
Yes, Your Lordship. If the claimant can help, I would appreciate it.
I'm sure they will.
Now, coming to page G121.
Yes.
Can you please read aloud the first paragraph?
So that is the email, constitutional documents, VK3. Email from Komal Saini to Nikhil.
VK4. Sorry, Mr. Vajani, I'm referring to VK4.
I think the better thing, Mr. Vajani, thank you for that. But the better thing is if someone can make a list in handwriting, if necessary, of the VK references in the Mr. Kapoor's various witness statements, and then they can be handed in at some time. I can look at them later, unless there's a need to go to a document. Thank you. Sorry, you were page 121, G121.
J292. J292, Your Lordship. That's the email dated 2nd October 2019 from Ms. Anjali Shivramakrishnan to Mr. Vijay Kapoor.
J292.
Attached as exhibit VK4 to the first witness statement submitted before the Honorable Court on 30th November 2020.
All right, thank you.
Thank you, Raj. G121. Mr. Kapoor, can you please read aloud the first paragraph?
I state that when a strategy document is being prepared, clients are obliged to divulge all information to their lawyers. And as such, Kochar and Company was privy to all discussions regarding the defendant number 1 and 2. The last email dated 2nd October 2019 is also after the loan recall notice was received by defendant number 1 from the claimant in the current proceedings.
So even after the loan recall notice was issued by the claimant's current lawyer was acting as your lawyer pertaining to the same transaction.
That is obvious from this email.
And all documents pertaining to defendants number 1 and 2 were produced by you to Kochar and Company in order to enable them to advise you on the strategy document.
That is true. In fact, the strategy document prepared by them was after seeking a lot of clarifications from us.
And the next paragraph, you specifically stated, I state that a conflict of interest has arisen in the present proceedings.
That is correct.
Paragraph number 8. You mentioned that defendant number 2, that's towards the end, last but one paragraph, one line. Defendant number 2 was created as a holding company to the defendant number 1 with no operating bank account. And so such allegations of fraud are false, wrong, and made with a malicious intent. Correct?
I'm sorry, I lost you. Which paragraph are you referring to now?
Paragraph number 8, G121, the last sentence, not the last paragraph under paragraph number 8, the last sentence under the first paragraph. I
Right.
state that the defendant number 2 was created as a holding company to the defendant number 1 with no operating bank account, and so such allegations of fraud are false, wrong, and made with a malicious intent. Defendant number 2 is a holding company.
No, this is defendant number 2, which I mentioned was not Velocity Ventures LLC. Velocity Ventures Limited. This is what I had. What I was trying to say is that when they were handling the Fujairah criminal civil case, a similar sounding company, which is Velocity Ventures FZC, had been created to become the holding company of defendant number 1, for which we had been to the notary and signed the necessary documents. So this is not number 2, that's an error.
It's an error. That's what I want.
Yeah.
Paragraph number 9.
Yeah.
You are referring to a bill discounting facility of 85 million signed with Noor Bank.
Yeah.
Who arranged this facility?
Both me and Ravi, we went and met Noor Bank, spoke to them, explained our business, and then they agreed to grant us a facility.
What if I say you were explaining the financial part and Mr. Ravi was explaining the technical aspects of the project? Is it correct?
Yeah, that is correct.
That is correct. Who was your contact point in Noor Bank?
I cannot recollect the name of a single individual, but basically we went to the branch and we were made to meet a series of officials, the branch head, the credit head, and we explained the business, what we were in, and that's how this was done.
Okay. You're saying in the first line, G122, no business was brought in by defendant number 5, despite projections and assurances at various points of time. Was it the obligation or the sole obligation of defendant number 5 to bring in projections or bring in new business? Was it the sole responsibility of D5?
When we had started this business, as well as when we had, brought in the other investors, Ravi had positioned himself to be the person who understands the technicalities as well as has the business connections with the companies which he was dealing with in the past when he was in Oman. So obviously it was always his role as both group CEO and managing director, as well as handling the entire supply chain part. It was his role to bring in the business.
And your background was completely financial and banking.
Well, background was financial and banking, but when you start doing your own business, you do get involved in many other things as well.
Ravi had no finance or banking background.
I mean, when you...
I'm only asking about the background.
Well, I cannot comment on that, whether he had any banking background, because when you deal in businesses, you run companies, it's not that you've never been to a bank, you don't understand how banking transaction happens.
That is not what we mean when we say finance and banking background. You are a senior banker, you know that. When I say somebody has a banking background, doesn't mean that he holds a saving account in a bank. He has worked in a bank or a finance.
At the same time, the point I'm making is that people over a period of time do get financial understanding of how businesses operate, how banking happens, what borrowing means. It's not like somebody just can shut himself out entirely.
But to your knowledge, he did not work in any finance company or banking institution.
Yeah, that is correct.
And going further down, you're saying that neither the defendant number 5 nor 7 was able to develop any business. Is that correct?
That is correct.
Why did you expect defendant number 7 to bring new business?
See, people who were in Dubai, right? Parag Gupta, for example, was the person who was representing those people because some of those people were in Dubai. Sometimes they used to travel. Parag Gupta was essentially engaged with D6 on a regular basis. D6 used to have a shop in Dera, and they were in regular trading business. And during the various meetings which you used to have for review of the business, which was in fact almost on every monthly or even once in 2 month basis, it was obviously passed around that look, if you could also pitch in and find out whether we can get some sales to Africa or whether we can do some business with any of the other countries where you're already doing trading business. So it was in that context.
You were also in, sorry, you were also in Dubai during that time.
That's right.
So you also had a responsibility to bring in new business or develop business.
Well, you can say in a general sense, but that was not my expertise. So obviously, I was looking more at what was already happening and how to make sure that we had the means to attend to that business.
When you say means, it's finance.
The finance, yes.
The 7th line of the same paragraph, what we are referring to now in G122, 7th line, you said thereafter, after my consistent efforts, the defendant number 1 received the credit facility from the claimant.
Right, that's correct. Can I explain something here?
Please go ahead.
As you see, the earlier facility which we had with Noor Bank was only a invoice discounting facility, right? And for actually running a business, what you need is 2 different kinds of facilities. One, a term loan, so that you can add new plant and machinery, you can bring in the fixed assets,
Capex.
as well as have a working capital facility also to buy raw material before you do the production.
Yes.
So in order to smoothen the process out, to give us more flexibility, we approached Union of Bank of India to give us a combination of those facilities.
Okay, understood. You say that in the last sentence of that paragraph. I also state that even defendant number 6 also presented to the board to get additional business from his shop in Dera and focus on the Africa markets which never fructified. That's what is right. Is that correct?
Correct.
Any proof that you made such a promise to the board?
These are minutes of the, those meetings which used to happen within our office or the factory. All the people used to sit around a table and this was discussed. So, we didn't really record minutes of every single thing, who said what, to hold them accountable. They're partners and owners of the business. So, if somebody says something,
you cannot support this statement with any document.
I'm not sure, but I could look at some old emails. If I can find something, I'll be happy to share it.
And can you recollect of any emails you sent to D6 complaining that you did not bring any new business as promised? Is there anything like that?
No, I think the interaction with D6 to 8 used to be in the monthly meetings mainly. It was not like I did not write any
monthly meetings. The interaction with D6 to D8 was only in the monthly meetings.
Yeah, largely.
They were not involved in the day-to-day business of the company.
They were involved in the day-to-day business in the sense that whenever any financial transactions were happening, any payments were happening, we did have their involvement because they wanted to see and look at what was being paid to whom, etc. So they were involved to that extent. But on a day-to-day basis, manufacturing or anything else was definitely something which they were not involved in.
Was their involvement more like from the investors?
No, because they were very active. They were very hands-on investors.
Okay. Paragraph number 10.
I'm sorry if I may complete. Essentially, if you have only investors, you probably meet once in 3 months or 6 months to just come and take stock of things. Here, initially the interaction was almost on a monthly basis or like 45-day basis or even once in 2 months.
You mean to say that every aspects of the company's business was timely disclosed to D6 to D8?
That is correct.
Paragraph number 10. You are referring to an internal forensic investigation in the first line.
Right.
Have you produced any proof before this honorable court?
No, I haven't.
You have not. Before conducting this internal forensic investigation, was any notice given to the other personal guarantors in this case?
No.
No. Were they in any manner involved or contacted for the purpose of such an internal forensic investigation?
No.
Who was Akash Garg?
Akash Garg was the group general manager finance.
Manager of finance. Was he reporting to you?
He was reporting to both me and Ravi.
He was reporting to both D5 and D4, right?
That's right.
But on financial matters, he was reporting to you.
Yes, on financial matters, he would come and discuss things with me first.
Yes. Now, going down, defendant number 5 in collaboration with other defendants had totally mismanaged the affairs of the company.
Right.
Any evidence?
Any evidence as in what I've submitted or any evidence do I have?
Any documentary form that you have produced before this honorable court?
No, because at that stage, I was just giving my initial response to whatever I had seen from the other witness statements.
So those documents, something you're saying, and look at the strategy discussion between the defendant number 1 and Kochar and Company, the law firm currently representing the claimant, and which is exhibited as DVK2 and VK4 respectively with witness statement of D4 accompanying the application. So what I'm trying to say here is that there are more documents given to Kochar and Company than what is produced before this honorable court pertaining to D2.
Mr. Shane, I actually had pulled out a lot of emails when we had this pre-trial hearing, and we were requested by the counsel for 6 to 8 as to what all different things were discussed and what was sent. And I had sent that entire bundle across to KPH. So those same emails are there on record as to what was shared.
So you mean the entire bundle of internal emails between the partners or stakeholders were all given to Kochar and Company?
That is right, because we were trying to find a solution as to how to save the situation for D2, how to save the businesses to make sure that there is continuity and we don't end up in distress.
You said the investigation was commenced to solve the mess created by defendant number 5.
Which paragraph is this?
Yeah. Take paragraph number 3. It was to solve the mess created by the defendant number 5.
That's right.
Did you solve it?
Well, as far as finding out what were the reasons why we had problems, that was concerned, we found out the reasons. And then to solve it, I started looking around for business and went and found this company which we could deal with. and brought that business opportunity to the table, to the bank, so that we could actually turn the company around.
And that did not happen.
That did not happen because the bank didn't cooperate.
Paragraph number 11. A serious allegation is made out. It's against defendant number 7, but since I'm going in the sequence, I'm asking you.
Yes.
There are emails from defendant number 7 which borders on the fringes of blackmail and intimidation, and I crave leave of this honorable court to produce them as evidence as and when required. Have you produced any such emails before this honorable court until today?
No.
When you say blackmail and intimidation, it amounts to criminal offenses. Did you report it to the authorities?
No, because I mean, we were still financial partners. We had business with the bank, and we obviously did not want to rock a boat to that level where it becomes a criminal complaint.
In paragraph number 12, and that's page G123.
I can see that.
The claimant had effectually collaborated with defendant number 6 and 7 and allowed them the exit which they have been demanding since no business happened. Is that statement correct?
See, if you look at the sequence of events which I already elaborated, that there was an MOU which was signed in the year 2017 for their sale of their shares. By 2017, sometime in September, I think we went to the notary finally to sign the sale of shares and have an amended memorandum and articles, right?
Yes.
Now, when the memorandum articles is signed and the documents are submitted, since most of this process was usually handled by the external PRO or the person who handles these matters with the notary, with the Dubai Economic Department, you assume that the trade license is just going to be a thing which will happen subsequently. I mean, the notary has signed, you take the documents, and that was the time when we knew that this has happened, and it is bound to be something which will come out sooner than later. So it is our duty to go and inform the bank, right? And when we decided to go to meet the bank, we went there in the month of November and alluded to them that yes, this is happening, this is likely to happen. In fact, we had actually cautioned the bank about this even before that notary thing happened, because we were in dialogue that this is imminent to happen because we've already signed an MOU, and the MOU was signed to bring a new institutional investor in, which is Adiwat, the fund. So we told them that they want to exit, they are exiting, and we are getting the PE fund in. And the PE fund, which is the Adiwat fund, was already known to the bank because they had already come and invested into the other group company, which is Velocity International Logistics. And by means of if you look at the documentation, they had already gone through their things, and it was there in their sanction letter that Adiwat will be investing into that business. So when the comfort had to be created, and obviously when the event happened, we went with the document. So in the month of December or November end, I explained to them that this has happened. And I also then gave them the heads up about the new business opportunity which is there with Beverly Hills Polo Club, the multinational company, the supply chain agreement which we gave to them. And essentially, if you look at it, that's the question which I asked Mr. Maniram even yesterday, that had you on your records confirmed to us that the 4 directors are still there, right?
Yes.
The defendants 6 to 8, as well as D4 and D5. Technically, there are only 4 signatories, but there were 5 people. Mrs. Makhijani did not have signatory powers. Either you allow us to operate the account, which means that if they had allowed us, even if argument's sake for day-to-day operations, Mr. Makijani or Parag or others having exited would not have technically given their consent to sign, they could have at least passed a resolution to appoint others to sign, given a mandate for other professionals to sign, maybe like Akash, maybe like Sandeep Chopra, maybe anybody else in the company. Then the operation would not have been hindered. So because we had given them the amended memorandum and articles of association, even they assumed that that sale has happened, and now it is only left for D4 and D5 to sign every document. Right? So because they also knew that there was a conflict, there was a dispute between D4 and D5, right? They were concerned and they were asking questions about it. But it was never at a breaking point that the business cannot function, because even though Ravi used to go to India, he was available, he was talking to them, he was signing documents, he was sending it by courier. And when he was in town, he would also go and meet the bank, he would also talk to them that we are all trying our best to make the business happen. So I think, if I may take a few minutes to answer this question, to look at the sequence of events, September and notarized documentation happens. In October, November, you start telling the bank about it. In somewhere around end November, beginning of December, you go and meet them, give them a copy of the document, which clearly establishes in their mind that now it's only D4, D5, right? And thereafter, they insist that, okay, that's fine, but you know, between you and Ravi, you sort things out and we'll go ahead, right? And then if you look at just after that, like beginning of 2019, around April, there was this civil case which was filed in Fujairah courts, right?
Yes.
Against Velocity Ventures FZC, correct?
Yes.
And in that, the first defense statement which we filed was saying that Velocity Ventures FZC is merely a holding company of Velocity Industries LLC, which is D1. And hence, it does not have a bank account and does not have operations. So there was no question of producing financials. And if it was created, it was also created like only a few months back, like 6 months back or 8 months back. That was the line of defense against that civil complaint, right? Till that time, Kocher and Company, after examining the documents we had given, was also under the same impression that it is Velocity Ventures FZC is the holding company of D1, right?
Yes.
And thereafter, when certain responses were received from your side, which is D5 side, were also along the same lines. Everybody was under that impression that the change has happened and the new memorandum articles is in play, and we are now going to be basing everything on that basis. And I do not know the specific clause reference, but even in Ravi's witness statement, initially I remember reading where he had mentioned the shareholders were Elements, Velocity Ventures, FZC, and you know, the new sponsor or the new local partner, right? So it was only in May, suddenly, that it was discovered that in the Dubai Economic Department, no change had happened. And that was discovered by Kocher and Company. And when they discovered that, they informed us. And I say us means they informed me that this has happened. Now, D6 and D7 and D8 had collectively been pursuing us and following up with Ravi and me that their personal guarantees should be released. Right? And when we found that this was a legal position, we gave them this option that, look, as per the Dubai Economic Department, there is a possibility that using the powers vested with the old sponsor or the old local partner, I'm sorry to use the word a little interchangeably because the way things work in Dubai, but the local partner had the powers to change the shareholder. And if he had changed the shareholder, the deadlock would have been gone. We had not yet discussed who the new shareholders will be, who should own what, but at least we could have gone to a stage where the company's deadlock would be out, right? And later on, when the suit was filed, I was again surprised to see that the suit was filed against all the claimants, including D6 to 8. So, you know, that's in that context is what I have mentioned this.
Thank you. And that's exactly my,
Please.
if you're done, I can ask the next question.
Please.
See, that's exactly my question. When you said allowed them the exit, that is number 6 and defendant number 6 and 7. This is what you meant, that exit effectively from the company, though their names were not officially removed from the trade license.
And also to then go freely to the bank to say Adiovat fund is now formally come in and we have a business plan. So please support us so that we can run the business.
So all parties involved, including the bank, effectively considered that D6 to D8 are no more shareholders or personal guarantors in the business.
It's my firm belief that was the case. Otherwise, why would they not allow this to happen?
And why this impression got spoiled? I'm referring to paragraph number 13 of your witness statement. How did this understanding between all parties, all stakeholders, including the bank, get spoiled?
See, my thinking is that during the course of the representation in the Fujairah matter, since it pertained to Velocity Industries, right? And when we had made this contention that it is the holding company of Velocity Industries LLC, right? They must have felt the need to produce the trade license and everything else put together as a bunch and go to the court and say, look, here it is. So when
you say they must have felt, who?
Kocher and company. So when they went to the Dubai Economic Department to, I think whether it's online or whether it is offline, going to the Dubai Economic Department to get a copy of the trade license, they must have discovered that this change has never happened.
Again, that was while they were, Kochar and company was acting on your behalf.
Yes, on behalf of the company and myself, because they were looking at the entire Velocity Group affairs.
That is when they collected this confidential information.
Correct.
It becomes in public domain only when the trade license is changed, not until then.
Absolutely correct.
And it is that information which completely destroyed the understanding between all parties, including the claimant, that defendants 6 to 8 are no more shareholders, are no more personal guarantors.
Correction. As far as personal guarantors is concerned, that is not discussed, because obviously unless and until the new owners are brought in, they intimate their head office. That process is something which I cannot comment on. But they definitely were sure that the Adivat fund is coming in, and it's a significantly sizable fund. It is already an investor in a group company, right? And where they had made financial, substantial financial commitments. Therefore, I did not anticipate that there would be any issue in resolving this. So only one thing can be true. If the bank says that they check electronically, do the renewals, everything online every time, and they do their due diligence, then they should have seen that 6 to 7 and everybody is still there. And then they could have come back to me and said, what are you talking about? Even if Ravi has some problems or family issues or something for which he's frequently going to India, that's fine. You have these signatories, why don't you use them to operate the account? And, Mr. Shaheen, if you would indulge me, the total amount of facilities at that point of time which were available to us were $6 million. I'm talking about only working capital.
Yes.
There was a term loan of almost $1.5 million, which was still lying unutilized. Right?
Yes.
So I submit to you that point of time, this supply chain agreement which we had to start manufacturing for this leading multinational, which was worth about $28 million of turnover every year, would have been sufficient to change the fortunes of the company or its future growth trajectory, right? And it was only the issue of who's the shareholder, and they were in their mind absolutely locked up that it is only 4 and 5, because even if you look at Elements or you look at Velocity Ventures FZC, the beneficial shareholders were only me and Ravi, right?
I'm not sure you saying that.
Yeah, and that was also done again, because in Dubai, when you go to the notary, when you create a new company, the process becomes far more tedious when it is a corporate entity, and that to an overseas entity which is becoming a shareholder, right? So it was discussed between me and Ravi that we will form these companies in our names, and later on one of the companies, which is the largest shareholding, will be transferred to the name of the PE fund or their nominated company. So that was the plan.
Why do you think that plan did not take place, did not materialize afterwards?
I think the plan did not materialize simply because the bank did not support the opportunity. And I once again submit that we went to the bank not only with that document copy, we went to them with samples, the samples of the products. I mean, they had gift packs, and the company in question is Beverly Hills Polo Club, which is a well-known brand. We went there with their gift packs. We actually distributed those gifts in the bank. Just as an introduction, just as an excitement that, look, see, this is what's going to happen in our factory now. And thereafter, I was advised that, look, because you need a larger working capital cycle, you need a longer working capital cycle, please submit a request to change the same facility in its nature from purely LTR to part LTR and part overdraft facility. Right?
Was that allowed?
No, it was not allowed, because I mean, we just submitted this, and thereafter in the month of January, we just got this revised renewal, which not only reduced the limits, but did not address what we had asked for.
Do you think any information which you had given to Kochar and Company during the time they were your lawyers could have influenced the bank's decision not allowing the additional facility requests?
I cannot comment on that specifically, but if Kochar and Company had all this information from us, and if they had also been representing the claimant, argument's sake, where they said earlier that they were representing the claimant and that advice was given on behalf of the claimant, then this could have saved the day. But if they were claiming to be my lawyers and later on coming in representing the the claimant, it is a conflict. On the other hand, if this information was shared with the claimant and they did not rely on it to actually help us turn the business around.
Was there a period, overlapping period, when they were your lawyers and they were representing the claimant?
I am not aware from which dates they were representing the claimant, because they had also given written opinions for about operation of account in the case of Velocity Food and Beverages, which was a group company, to the bank.
Bank of Baroda.
To Bank of Baroda as well as to Union Bank, both. Right, because Velocity Foods had an account in both places. So that was it, advice was being given. Now, whether that opinion which they give is being given on behalf of the claimant, obviously if the claimant is going to rely on it, it means that it is on behalf of the claimant. So I'm not sure of this clear overlap, but definitely this information, if it had been brought to the notice even of the claimant, would have definitely not allowed situation to deteriorate to this level.
Okay. Now I'm coming to the second witness statement.
Please.
G149.
Yes.
Are you familiar with the RDC provisions?
No, I'm not.
You have quoted RDC provisions at least 6 times in this witness statement.
Yes, that was advice which I got from the lawyer, our counsel, which is Al-Banna. So they helped me with that information so that I could include it in my arguments.
So can I say it was not your own words, this witness statement?
Except for those particular references, this is my witness statement. It is basically something where obviously I'm not able to cross-reference which RDC rule pertains and says what. That is something which I would have to take externally.
Now, you have mentioned in this one several places, I submit there are no comments against paragraph 7 to 17. In short, I have noted it, no comments on paragraphs 1 to 5, 7 to 17, and 20 to 27. This is a second witness statement on behalf of the fourth defendant to the reply witness statement on behalf of the claimant.
Right.
You submitted the second witness statement in reply to the witness statement of the claimant.
Right.
You have mentioned in this witness statement, you have no comments on paragraphs 1 to 5, 7 to 17, and 20 to 27 of the claimant's witness statement.
Right.
What if I say you were hand in glove with the claimant in doing everything? That is why on many aspects, you have no comments on what the claimant has got to say.
That is incorrect.
That's correct. Paragraph number 10. You're referring to Mr. Parag Gupta. And you are saying that I find that Mr. Gupta has categorically blamed the fifth defendant in paragraph 19, while in his first witness statement, Mr. Gupta had blamed me for all the alleged mess. Correct.
Right.
In paragraph number 11.
So was there a question? Was there a question about that?
Is that correct or not? Let's stand by that.
I see. Okay.
Be confirmed. Paragraph number 11. The statement that the counsel for the claimant had the consent of the claimant to mediate the matters and assist the fourth defendant admittedly creates a conflict of interest. What do you mean by that? You can read that paragraph for yourself. I don't want to repeat the whole thing. And you can explain what did you mean by that.
Could you kindly just refer the lines which you want me to read? The paragraph 11?
Paragraph 11, 6th line.
Okay.
You can read the whole paragraph to understand it in context and then explain.
Yeah. So you want me to read only till the end of that paragraph?
Yes, that page alone. No need to go to the next page. Just read that paragraph till the end of the page. And then for yourself, you read and then you explain to me what do you mean by this statement. The claimant had the consent of the claimant to mediate. The counsel for the claimant had the consent of the claimant to mediate the matters and assist the fourth defendant admittedly creates a conflict of interest. Because it's not clear to me mediate with whom.
See, basically what I'm saying is that if they are denying that there was no conflict of interest, which is Coaches and Company had given us in response to those paragraphs, that they were only merely dealing with me on a Pujara civil case and they were not aware of any other details or anything else going on in the company. So what I intend to say or explain here is that there was no documentary evidence relating to the termination of services to the fourth department. So there was never any termination notice sent to me or a termination letter sent to me that we no longer represent you. Right?
Yes.
And the statement that the counsel for the claimant had the consent of the claimant to mediate the matters. Mediate the matters means like they were acting on behalf of the claimant to try and mediate between me and the other, defendants, or do something of that sort. That is something which there is no documentary proof, right? And this itself creates a conflict of interest irrespective of the court, which basically means that they have information. On one side, they are saying that they were acting for the claimant. On the other side, they said they'd stopped and, giving advice to me. The mere fact that they stopped giving advice to me does not mean that they can start on the same subject, give advice to the claimant now. Yeah. That's what I was intending to say.
And in the same paragraph number, but the next page, G152. Sixth line, you again say, my counsel has breached the confidentiality of the agreement between the counsel for the claimant and the 11 defendants. Why do you say so?
Mr. Shaheen, before you answer that, you read that as though Mr. Kapoor was saying my counsel has breached the confidentiality of the agreement. But if you read this whole sentence, he's referring to a submission by the claimant or by someone.
Yes, it starts by saying, thus, it is my submission that this admitted conflict of interest by the counsel of the claimant in this case have thoroughly vitiated the entire proceedings. It stops, full stop. Relating to the submission that my counsel has breached the confidentiality of the agreement between the counsel for the claimant and the relevant defendants, I submit that any disclosure to the court is considered as exception to the terms of confidentiality, and the same was important to bring out the conflict of interest in the current case. So I'm taking that portion. My counsel has breached the confidentiality of the agreement. It is his submission. To submission.
Yeah, correct.
Whose submission?
That's what I'm asking him to clarify. Relating to that submission, I thought it's the D4 submission. Is that correct?
Okay.
You can read the whole paragraph and then explain what do you mean by that statement.
Basically, what I am saying here is that if you look at the starting of the paragraph, which is saying that if they were saying that they were claiming that they had the consent of the claimant for assisting the defendant number 4 and other defendants, then a consent was equally needed from me. Because I never knew that they were representing the claimant.
Yes.
And if they were going to go into the claimant and represent them, the claimant has already clarified that they never retained them before the end of 2019 or beginning of 2020 when this claim was filed. So even if they say that they had the claimant's consent, I'm saying, how can they claim that claimant's consent without my knowledge or without my approval?
I see.
Secondly, if you look at the further paragraph, when I say my counsel, I mean Kocher and Company, not the counsel while sending this witness statement, right? Has breached the confidentiality agreement between the counsel and claimant and the relevant defendants, and I submit that any disclosure to the court is considered an exception to the terms of confidentiality, and the same was important to bring out the conflict of interest in the current case. That means even if they said it was that what they are doing in a current court case, and that is considered to be an exception, even then they should have first informed me. That is what I meant.
Thank you.
In the next paragraph also, you are referring to a comprehensive relationship of the counsel for the claimant with the defendant numbers 1 and 2. Not you. The sentence is quite clear. Comprehensive relationship of the counsel for the claimant with defendant number 1 and 2. The arrangement was comprehensive not only in terms of giving strategy opinions, but also went to the extent of mediation with the counsel for defendant number 5 to solve the issues with defendant number 1 and 2. So here, the arrangement was a comprehensive arrangement as far as D1 and D2 are concerned. The arrangement you had with Kocher and Company, the counsel of the claimant in this case.
See, if you look at when we engaged them, I had known Anjali earlier, so I had submitted to her that look, in the current situation, the company is not doing well. I don't have personal resources. So let us sign a retainership agreement, and we are willing to pay some money to you upfront, so which will last for a year, and it should advise we should be on any and every issue which we face, so that we can know which direction we are heading. Right now, if you look at this, the objective primarily was to see how we could find a way to solve the deadlock, right? And Mr.
Yes.
Shaheen, I draw your attention to the opinion given to the bank about allowing the signatures of one of the two partners. In the case of Velocity Food and Beverages, that as per the memorandum and articles, it permits any one of them to sign, right? Now,
I don't agree, but that's what you're saying.
I agree, but I'm saying that that was an opinion provided, right? Now, to what extent does that help in terms of solving a dispute in between D4 and D5?
No, my concern is not between you and D5. My concern is more about.
I'm just trying to answer your question. I'm saying the fact that an opinion is given to the claimant, which means this claimant as well as another bank, that in the case of Velocity Food and Beverages, one person's signatures to operate the account should suffice, because that is what the memorandum article states. So the objective was to solve the deadlock and allow the business to continue. Correct? And that is why I stated that they were acting on behalf of the D1 and D2 to find a way, to find a methodology where we could operate the accounts, so that we did not want the company and the asset or the account to go into distress.
Understand your explanation. My concern here is comprehensive information about D1 and D2. D2 is my client in this case. So comprehensive information about D1 and D2 were provided to Kochar and Company.
D1 in much more detail, D2 more in terms of just the documents, which means the incorporation documents and whatever. Just to put into context why they are a shareholder, who has what rights, who has what powers. That one.
What is the activity of D2?
D2 was a company which is Velocity Ventures, which is a company which was formed between me and Ravi to represent our shareholding in different businesses.
Was it a holding company?
It was a holding company.
What is the capital of that company?
I don't remember it offhand, but when it was created in the Ras Al Khaimah free zone, I think it was probably 10,000 or something similar to that, $10,000.
Did it have any other assets on its own? D2?
Assets were mainly investments into the other companies.
Did it have a balance sheet on its own?
I can't remember, but I'm sure something must have been created, because it was a company which was existing, so balance sheet must have been there.
Did it have a bank account?
Yes, it had a bank account.
D2 had a bank account. Who were the signatories to D2's bank? I'm not asking about D1. I'm asking about D2. Who were the signatories to D2's bank account?
Both D4 and D5 jointly.
Jointly. What was the value of the corporate guarantee provided by D2? The facility was given for 10.4 million, 2017.
Right.
So did
I don't recollect what was the value of that one at that point of time.
10.4 million was the value of the facility given in 2017 by the claimant bank to D1.
Right.
What is the net worth of D2?
As on that date,
Yes.
I don't recollect. I mean, I'll have to look at some documents to find out.
Would it be correct if I say it was not even $1 million?
Yes, because it was early days. In 2014, Velocity Ventures was just a shareholding between me and Ravi, and there was nothing. There was no assets at that point of time. The other investments happened later.
Do you know that under the laws of UAE, it should be within the means of the guarantor to repay the amount taken by the borrower in order for the guarantee to be valid? Are you aware of that?
No, I'm not aware.
You're not aware of. Did anybody check the needs of D2 from the claimant side? Did anyone do any due diligence, financial due diligence?
They do a lot of due diligence on their own, but we were never specifically asked for that information.
Okay. Coming to third witness statement. Paragraph number 4. You say, at the outset, I thank D7 for this third witness statement only for the sole reason that while the focus of his first witness statement was totally biased and one-sided against myself, which prompted me to respond accordingly. D7's third witness statement has apportioned the blame between myself and D5 for the alleged failure of D1. This is the fourth paragraph. I read it fully. It's a short paragraph.
Yeah.
That's why I read it.
I've read it as well.
Are you thanking him for blaming you partly for the alleged failure of D1?
No, it is a statement because I wrote the witness statements myself. As you can see that this is not being referred to a lawyer or something. So it was, and I am not very familiar with how DIFC courts functions and what the witness statements mean. This is just an ironical statement that if you look at D7's statement number 1, the first witness statement, it had not mentioned D5 at all anywhere in that statement. And in fact, allegations were made that, we relied on whatever he said and basically we did whatever he said and things like that. So I just wanted to bring that, irony out of that, okay, so thankfully now you are at least in your next statement blaming both D4 and D5 for whatever happened to D1. So this is just a statement to note his contents of his first witness statement and how they had changed between the third witness.
Are you happy to take 50% blame?
Sorry, I didn't hear that.
Are you happy to take 50% blame?
50% blame on what basis? I mean, you're talking about a failure of D1. D1, we don't hold 50%, do we?
No.
That was neither Ravi nor me.
The third witness statement of D7 has apportioned the blame between myself and D5 for the alleged failure of D1. D1 has failed, and the allegation is that you and D5 are responsible. This is what the third witness statement of D7 says. So are you happy to take 50% blame is my question.
No, I am not happy to take the blame.
Because that sounded like an admission. That's why I asked you.
Sure.
Paragraph 5.3.
Yes.
Regarding the withdrawal replacement of personal guarantees, D7 is fully aware that it is a long drawn process and is not limited to signing an agreement for that purpose. In fact, there was no cooperation from D5 regarding this issue, which dragged it on for several months. Even after several requests from D7, D5 did not bother to appear before the notary for signing the document. Have you produced any proof to show that D7 had made such a request to D5?
See, D7 and D5 were both in Dubai and they were talking to each other on the phone regularly. And D7 would talk to me and he would also talk to D5, and he was obviously telling me what was going on between the two. So it's my basis is that conversations. As far as written emails are concerned, I haven't submitted any written document, but if necessary, I can try and search for an email which may refer to that.
So it's your assumption that D7 being in Dubai might have requested D5 during their conversation. You haven't heard anything like that.
No, I haven't heard, but this is what D7 had informed me, that he has been talking to D5 and he's saying, no, it's not possible now, maybe next week, and things like that.
And
see, when you are in the same country, you don't write emails to each other.
Were you in Dubai at that time?
Yes.
But very soon you left Dubai after these happenings in 2019.
So these happenings are not 2019. These are 2018 when the notice document happens.
Again in 5.5, second sentence, what he has failed to state is that this was owing to the non-cooperation of D5 to approach the notary for signing the share sale agreement in spite of D7 following up with D5 continuously. Here, I'll read the previous sentence now. D7 is again right in paragraph 24 of his witness statement under response hearing when he mentions that the first SPA was entered into on 19th November 2017, while the transfer of his shares did not take place till September 2018. Okay.
That's correct.
What you're saying is that D7 did not state in the witness statement that it was non-cooperation of D5 to approach the notary for signing the share sale which caused this problem. D7 did not state that.
Yeah, that's what I pointed out.
Yes. Coming to the fourth witness statement.
So when you, just on that last point, there's a bit of ambiguity in the question and the answer. When you say D7 did not state that, are you picking up on the third line, what he has failed to state? Or are you saying that D7 did not state to me at the time that he was following up with D5 continuously?
I understand your question, Your Honor. The correction was with respect to him not stating it in the witness statement.
Yes.
Whereas
Yes, I see.
I have said earlier that during that period of signing the original share purchase agreement and the notarization happening in the notary, there were several attempts to align both me and D5 to appear before the notary so that the notarization process could be completed. So that's a separate thing which I have covered already. It is only his failure to mention that in the witness statement, which I have pointed out in my witness statement.
Yes, I see. Thank you.
This was
That's right.
Fourth witness statement and fifth witness statement. I'm not asking any questions. Sixth also, I'm not asking any questions. Even on the seventh witness statement, I'm not asking any question. I'm coming to the eighth witness statement now.
Could you be kind enough to give me a reference number?
G324. Your Lordship, this is mainly related to the conflict of interest.
Yes.
And it's all written there. So
I'm sorry.
it's all written in the witness statement. So I don't want to take time by taking him through those statements in the witness statement.
Of course, examination is only if you want to challenge aspects.
No, I don't challenge any of these statements. It's only to reaffirm if at all I have to do something, but it's already written there. Your Lordship has read it.
I see.
So which page should we go to, Mr. Shaheen?
Please bear with me.
Sure.
Just few questions without referring particularly to these witness statements.
Sure.
But I may refer in between also. According to the resolution of the company and the constitutional documents of the company, I'm particularly referring to the board resolution.
Mr. Shaheen, I think Mr. Vajani has disappeared. I just don't know whether that's accidental or whether
He's back. He's there.
he's back. That's fine.
We would like to see you, Mr. Vajani. That would be there.
I'm sorry, Mr. Shaheen, I interrupted your question.
No problem.
Sorry, Your Lordship, I was just sipping some water and I didn't want to do it on the screen, so I put it off.
Yep. Thank you.
See, in the first witness statement, in paragraph 3, G119. Oh, is it this one? Yes. I think the last sentence of paragraph 3, you're mentioning that if the facility has been made available till 29 September 2019 as confirmed by the claimant. So I would be right if I say that. So are you agreeing with the claimant? The facility was taken until 29 September 2019.
I mean, that's the sanctions and the renewals thereafter. And, you know, I confirmed that earlier to you that 2018 renewal happened and thereafter 2019 renewal was communicated, you know, later on. So the facility agreement is dated 2017.
I asked you this question again. I'm just reiterating because any financial document executed on behalf of D1 should bear 2 signatures according to the board resolution, correct?
Yeah.
So if at all a facility renewal has to happen to be accepted on behalf of D1 also, there should have been 2 signatures accepting it.
The bank used to accept one signature for such requests, not 2. In the
Bank-
past, there have been many times.
The bank used to accept your single signature.
Or even one signature. In fact, in the past, sometimes even like I was not there, Ravi would have signed.
Okay.
Because that is just a request. Thereafter, only when the formal sanction or other things come, then you have to accept it becomes 2 signatures.
In paragraph 4 also, you are referring to clause 21.17 of the facility agreement. Paragraph 4, G119.
Yeah, I'm there.
And this facility agreement is the one in 2017.
That's correct.
Of which one? Are you aware of the case number 384 of 2020 before the Court of First Instance Commercial Fujairah, which was filed on 22nd September 2019?
I cannot remember the case reference number which you're talking about, but is it a case which was filed against Velocity Ventures FZC?
The judgment has been produced and it's in the hearing bundle I3353 to I3363 for the parties.
Do you want me to go to that judgment now?
You can see the first page itself, you will know who are the parties.
So what is the reference number?
3353 to I3363. For the parties. The claimant is D5 and the defendants are D4 and D2. Not D2, Velocity Ventures FZC.
Hold on, I haven't found it yet. 3352.
3353, Your Lordship.
3353. Wait a second. bundle I.
Yeah, I've opened that page.
Okay. So you are
I haven't yet. I will give you the reference again.
I3353. Is that correct, Mr. Shine?
I see. Okay. Yeah.
You were aware of this case when it was filed.
That is correct. In fact, that was what was being handled by Kocher and Company.
You did not represent yourself in that case.
I think initially, because that's why I'm trying to understand whether this is the same case or this is some additional case. I'm not sure. That is why I'm asking. And what is the nature of this case? Is this when the D5 had sent or filed a case against Fujairah when Velocity Ventures FZC for not producing books of accounts or something like that? Is that the one?
You saw the first page now, where the names are written of the plaintiff and the defendants. And I read it also. I3353.
Right.
Did you represent yourself in this case? Did you defend yourself in this case?
I don't recollect.
You don't recollect. I3360. If you go to I3360. And if you look at the dictum, for these reasons, the court judges in presence by committing defendants jointly there between. So the court is noting your presence before the court.
But I was never there in this court. This is dated 21st June 2020. Was not possible for me to be in the court then.
Did any lawyer submit a power of attorney on your behalf?
That's what I am trying to recollect, because when Kocher and Company was representing me, they would have engaged a lawyer in Fujairah to handle this matter. And I did give a power of attorney to that lawyer. But from my understanding, when that case was continuing and Kocher and Company had also sort of stopped representing me and moved on, thereafter I had no control or no knowledge of what is happening in that case. Because I had no direct relationship with the local lawyer. I had no direct relationship with the local lawyer. It was handled by Kocher and Company, and they would have appointed a local lawyer.
We discussed about a criminal case in Ras Al Khaimah. The criminal case number 3837 of 2019. It's produced before this court, the judgment issued in this case. Hearing bundle I3445.
Yeah, I've opened this.
Ever since this document, this judgment was produced before this honorable court, you received a copy of the judgment and you were aware of it. Even if you deny your knowledge about the case previously, once the document, the judgment was produced before this honorable court, copy was served on you, you were aware of it, it's added to the hearing bundle too. Correct?
I can see that you've added to the bundle.
What are you going to do about this case?
I will go through the contents of this judgment and see if it is, it has to be contested.
Are you aware of a limitation period within how many days you have to file the appeal?
No.
You are advised by a lawyer in this case too.
No.
You're not advised by a lawyer in this case?
No.
Al-Banna and Company is advising you. You just mentioned few minutes before.
Al-Banna and Company was advising me only in the DIFC case.
That's what I'm asking. This case judgment is produced before the DIFC court. You are aware of the judgment, and a lawyer is advising you in this case. It's come in the witness statements also. What are you going to do about it? Are you aware of the limitation period for filing the appeal?
I'm not aware of any limitation period.
Not aware of it.
But as far as I'm concerned, this is an ex parte judgment where I never appeared in the court, never deposed before anybody. Nobody asked me for any information. None of the experts ever contacted me, nothing. So I have no knowledge of this case at all.
Few minutes before you said you went to the Ras Al Khaimah public prosecutor and gave your testimony.
That was when it was a police complaint. When it became a case or anything, I have no information and nobody informed me.
Okay. There were illegal payments and transfers undertaken by you to companies owned by you from day one in the range of $666,837. You would have seen it in the expert report of D5. What do you say about
I have not gone through the contents of this whole submission. In fact, you have submitted it, I think, only very recently. I have not had the chance to go through this. So I cannot respond to any questions or any allegations which I can see in this order.
And there were illegal payments, $2,207,099 also. So you cannot comment on that.
If it was a matter which was adjudicated in ex parte, if it's a matter which I never got any notices, if you had appointed any expert in the matter, nobody contacted me or anybody else, I mean, how do you expect me to comment on anything like this? For me, these are just mere allegations.
Can you look at document J126, J127? That the same way it is in the hearing bundle?
I'm sorry, which reference number are you referring to?
J126 and J127. I'm just showing you a sample of some of the transfers made by you, and this sample is of transfers made to a beneficiary named Multi-Dried Pack. Do you recollect who's this Multi-Dried Pack?
This is what J126?
J126 and J127.
No, I'm not aware. I mean, these are transactions, and to remember very specific transactions and that took so far back, and I wouldn't have any recollection.
Can you look at those two documents which are in front of you, J126 and J127?
Yeah.
And have a look at the signature of D5 in it. Do you recognize the signature of D5 in that?
Yes, I can see that.
Don't those two signatures in 126 and 127 look exactly the same? Even the dot, everything. Identical.
I mean, I'm not an expert. I mean, they look similar. That's all I can say.
What if I say these signatures were copy pasted by you without the knowledge or consent of D5?
That is incorrect.
That's incorrect. Can I request you to look at I2809? I2809.
I2809.
Got it?
I'm still scrolling. Its system is a bit slow. Kindly bear with me.
It's all right.
2809.
Yes, Your Lordship. This is a request for transfer of money from the account of D1 to a beneficiary called Synergia. Am I right?
Wait a second, please,
Yes, Your Lordship.
because it's right at the end of a section. Right, okay.
I-209, a request for transfer of money from the account of D1 to a company called Synergia General Trading Company, LLC. The amount is US dollar 620,000.
Yes.
Do you know who is the owner of Synergia General Trading Company?
I definitely remember that in Synergia there was, I mean, on that date, who was the owner? I mean, I cannot comment on that because earlier Synergia used to be owned by the same sponsor as Ravi's company and some of the other individuals, but I don't recollect as on this date who was the owner.
Did you directly or indirectly hold any beneficial interest in Synergia?
No.
Did you directly or indirectly hold any beneficial interest in Synergia? No.
No.
See, this transfer request bears only one signature.
Right.
Did the bank act upon this transfer request? Was the money transferred?
I believe so, because all this was handled by the finance team, and obviously, if they have submitted a request and if it had not been done, they would have come back to me. But if this was, they didn't raise an exception, it must have gone through.
I say this transfer was done without the knowledge or consent of D5 by you.
No, that is not correct, because any transaction, anything had to be discussed between D5 and the finance team as well as the bank, and only then a transaction could have taken place.
Okay. You can close that document. Hearing bundle I-3007 and I-3008, the continuation page. Correct? This is December 2018. A request to the claimant for change in credit facilities, some changes in the credit facilities. 10th December 2018.
It's I2975 or
I-3007.
okay. Yes.
This is dated 10th December 2018.
That's right.
On the letterhead of Velocity Industries LLC, which is D1 here.
Right.
It's a request to the claimant bank to make some changes in the facilities.
That is correct.
It was signed only by you. No other person has signed this letter on behalf of D1. It bears only one signature, and that is your signature.
That is correct.
Correct.
But as I had pointed out earlier, such requests which were sent to the company for bank for renewal or others were normally sent by one single signature. They did not insist on two signatures on such documents.
For a senior banker, if a company's board resolution very clearly says that any document requires two signatures to bind the company, can a document signed by only one person be acted upon?
Mr. Shaheen, if I remember correctly, during that period in December, I don't think Ravi was in UAE. And in such cases, when either the person is not available or is traveling, the bank would take one signature. But in this case, if you look at it, this is just merely a request asking them to consider changing the nature of the facility without any enhancement. So the total amount remains the same. And this was also a long pending request in our discussions, because not only because of the new business which we had on hand, but if you see how the LTR facility operates, you have to do a telegraphic transfer from the branch in DIFC, which is Union Bank, which is in US dollars, to any supplier who is in Dubai and his facilities are in AED, which is Arab dirhams, right? So usually a lot of money used to be lost because of exchange loss. I have pointed that out also in this letter, that in the past, if you look at, if you read the point number, if you look at the point number 1 itself, when we make the payment in dollars, the receiving banks use their own exchange rate, and this leads to exchange losses during such transaction. When we consider the volume of procurement we need to carry out, this exchange loss accumulates to a considerable amount. For example, in the financial year ended 30th June 2018, the exchange loss on account of this alone was 248,000 dirhams. So that was another reason to just change this. So it gives us the flexibility which we need in terms of the longer working capital cycle, but also solves another problem which was causing loss to the business. So this is just a request letter. It's not a commitment. Even if they acted on it, they would come back and give us a revised letter, a sanction letter, which again would have to be signed by both of us.
Your explanation sound exactly like the explanation given by the claimant's witnesses in this regard.
I mean, it's a fact that basic request letters were they never insisted on two signatures.
So there were many instances where you would have signed alone and the bank would have acted upon such requests.
Not only me alone, there are many instances where Ravi is signed alone, because just because of convenience, if I'm not available, he has signed. A request letter is not, it does not become legally binding till the time it is accepted, and then they come back with this thing. So in this case, if you see, after making detailed presentations to them, asking them to consider this request, what came out in the beginning of January was a renewal letter where they reduced limit. Instead of altering it or forget about enhancing it, it was brought down.
Have you produced any document signed by D5 alone for such purposes on behalf of D1 before this honorable court?
No, well, I wouldn't be in possession of such documents. I mean, it will be the claimant or the bank would have that in the records.
I'm referring to D5 expert report. Hearing bundle, table J18.
J18.
Yes, Your Lordship. And now I'm directly going to J193. That's part of a bank statement, J191 to J238.
You want J193?
J193.
Yes.
Can you tell me the period covered under this page, which is 169 of page 169 of 2214, J193, the period covered under this statement, from which date to which date?
It's 26th January 2016
To
8th or 9th February 2016.
D5 says this is part of the statements you sent to him when he asked for the bank statements of the company. You send it to him, this statement, and this is part.
I have never sent any statements to D5. All the financial records, bank statements were with the finance department. And if the finance department, somebody asked the finance department to supply something from the records, they would supply it. Because D4 and D5 both are, owners of the company. He's the CEO and looking after the finance. So I have not sent any statements to anybody.
So you deny that statement from D5 that this particular bank statement was sent by you to D5.
Yeah, I mean, these are bank statements which are not even in my possession. They're all with the finance department.
Okay. Now you go to J136. Have you seen it? J136.
Just give me a minute. I'm just getting there. Okay. J136.
Yes.
Yeah.
Can you tell me the period for which this particular page is issued? From which day to which day?
19th January 2015 to 1st February 2016.
Is it not overlapping with the previous statement that you saw for the same period, J193? You can check again. You can note the date and check again, J193.
Yeah, it does overlap.
Yes. The entries on the same date in both the statements look very different. And D5's expert report has pointed out that. What do you say about it?
I have no knowledge of what a bank statement and that too from the bank, and these are all photocopies or scanned copies which are being shown here. So I cannot comment on a statement like this. In fact, one of the things which is there as far as the expert report of D5 which is concerned is that from where were these documents obtained, who gave this, how it was verified. Nothing of that sort has been covered in that. So how can I comment on the document which is just placed before me by somebody who is considered to be an expert and who has submitted a report?
D5 says that you manipulated, you changed the numbers in the bank statement.
That's ridiculous, I mean, I don't have even access to these accounts, and these are all handled by the finance team. I don't go personally looking at bank statements and individual entries on dates.
Are you a shareholder in Launchpad General Trading LLC?
Me? No.
Are you an authorized signatory of Launchpad General Trading LLC?
No.
Hearing bundle J243. Third paragraph of the expert report.
J243.
J243, Your Lordship.
Yeah.
Hang on.
Third paragraph of the expert report. How did you obtain bank statements of launch?
I did not obtain. The expert, while conducting his work, spoke to some people in the finance department, some people who were former employees of Velocity Industries, and I think that's what I recollect. He said that there was an email from Mr. Ravi to one of the finance team members, which enclosed this statement for to them, and that is how they forwarded it to him.
That's your explanation. So Launchpad had received money from companies like Golden Product General Trading LLC, Synergia General Trading Company LLC, and Thames. In Thames, what is the shareholding of D5?
Again, I don't recollect. I mean, you'll have to refer to the expert when you depose him, or we'll have to go through the documents when I cannot remember who's the shareholder of that.
Will it be correct if I say it was 1%?
Again, I cannot comment. And as far as Thames River is concerned, it's a company which is something which I don't even remember the name as of now. It is a company which has been seen in my transactions, but again, in what context, I'll have to recollect myself.
And in companies like AgriChem, Golden Product, Synergia General Trading, D5 had no shares.
D5 had
No shares, no involvement. I just have one suggestion. You were very close with some of the officers of claimant. You acted hand in glove. They facilitated illegal payments from you for purposes not beneficial to D1, and thus the business of D1 collapsed. That resulted in this case.
So I deny this allegation, and I have nothing more to say on that.
That's all, Your Lordship. Stop.
Thank you very much. Now, we've had quite a long run. Ms. McGlone, do you have any realistic idea of how long you're likely to be with this witness?
It should be well under an hour, my lord, but in light of the fact that we've been quite a long time, I wonder if we might have to take a break at this stage.
I was going to suggest half an hour break.
Half an hour should be fine, yes.
Just thinking ahead, that will take us to
UK time, 4:20 Dubai time, I believe.
4:20 Dubai. Well, let's work UK time because that's what I'm working in. That would be 1:20.
Yes.
And that will give you time to finish before 3 o'clock, would it?
Yes.
I think realistically, we're not going to be able to call in any other witness. But I would like to make sure there's time for a discussion at the end about timing. So is half an hour enough, or can we afford 40 minutes?
I'm in your lordship's hands.
It just depends how realistic your estimate is.
My lord, it's going to be shorter than the other cross-examinations which you've heard from me. I don't anticipate it being, it may well even be less than half an hour.
Right, okay. Let's resume at 1:30 UK time, which is 4:30 Dubai time. Mr. Kapoor, can you be back here at, I'm not sure what time it is in India. Can you be back here at 1:30 UK time or 4:30 Dubai time?
All right.
And talk about.
And 6 o'clock, right? 6 o'clock India time.
Right. I can't help you on that. I'm sure you're right. Thank you very much.
Thank you, man.
We'll resume then. Thank you.
Thank you, my lord.
Are you ready to resume your cross-examination, Mr. Kapoor? You're muted.
Yes, Your Honor.
Thank you. Right, Ms. McGlone.
Thank you, my lord. Mr. Kapoor, good evening, as I think it is for
Good
you
evening.
now. Mr. Kapoor, we've heard quite a bit this week about your communications on behalf of D1 with the bank. Now, it would be fair to say, wouldn't it, that you took the lead in D1's relationship with the bank?
That is correct. At the initial stages to get the facility, yes.
And it makes sense that you should have taken the lead because, as we've heard already today, you dealt with D1's financial affairs, didn't you?
Well, the D1's financial affairs were handled by a separate finance team, and they're like 6 chartered accountants working there, right? So yes, there was supervision, but I mean, I was not dating on a day-to-day basis.
Of course, but I think you said earlier, Mr. Kapoor, that you handled the financial part of the business and Mr. Kuchimanchi handled the technical part. And that's correct, isn't it?
That is correct, but I just wanted to qualify that it's not that I was doing it alone.
Of course. And could we go please to J240?
Yes,
Now, this is the report of your expert, isn't it?
that's correct.
Could you just go to J246, please, a few pages on?
Yes,
Yes. And the bottom paragraph of that page, your expert states that the role of D4, that's you, was restricted to oversee the financial operations of the companies. You see that?
that's right.
And that confirms what you've just said, doesn't it?
That's correct.
If you could go next, please, to I-73.
Sorry, just before we move on, if you read that full sentence right up to that point where I was restricted to oversee the financial operations of the companies to ensure the same had enough money to run the business with delegated authority to the finance team and to specific departments to see the operations.
Yes, yes.
That's correct.
Yeah. On to I-73, please.
Yes, I have it in front of me.
And this is a director's resolution of 17th March 2014. And if you just look at the last paragraph of that page, we see that directors had resolved that D5 and you should be the authorised signatories. Do you see that?
That is correct.
Yes. Now, I'd like to ask you a couple of quick questions about the share sale. Could you go please to I-2387?
I-2387.
2387.
Yes, please.
So we see this page, there's an email from a Mr. John Ellis, dated the 13th of November 2017, and it's addressed to you, isn't it?
That's right.
Yeah. And I'll let you read it to yourself, but it indicates that you've been able to get a green light to the proposal.
That's right. That's correct.
And then at the top of that page, we can see that you've forwarded it on to Mr. Akash Garg. Am I right in thinking that Mr. Garg was the CFO of D1?
That's right.
And then if we just go over the page to I2388, please.
Yes, please.
And then at the bottom of that page, goes on to the following page, but you don't particularly need to read that. There's an email from a Mr. Paul Boskmer, dated the 14th of November 2017. So it's the following day. Do you see that?
That's right.
And he says, "Dear VJ, thank you for your time during the call along with John today morning." Was that a reference to John Ellis?
John Ellis, yes.
And then he explains that we've been asked to take over the transaction. I'll be your point of contact. And just further up that page, we can see that you forwarded that email on to Mr. Garg, and he then forwarded it on to D7. You see that?
That's right.
And if we could go over the page onto I2389.
Yes.
Yes. And about halfway down that page, he says, "I'm enclosing the term sheet for the transaction for acceptance by your stakeholders."
That's correct.
Yes. And if we could go on a couple of pages from there, please, to I2391.
Okay.
Okay. And this document has a date of the 14th of November 2017.
Right.
It's headed as being for your attention, and it states that it's a binding term sheet. Do you see that about halfway down the page?
That's right.
Yes. And just underneath that, it says that it summarises the principal terms of the transaction contemplating a purchase of equity shares of Velocity. Yes?
That's correct.
And this was to be the sale of D6 to D8 shares held via D3, wasn't it?
That's correct.
And if you could go on, please, to I2392.
Yes.
We see that there are two columns here. So on the left-hand column, a summary of what the right-hand column is about.
Right.
And the third column from the top is headed financial due diligence. Do you see that?
That's right.
And it reads, audited financials have been shared and management has advised that the company has obtained enhanced term loans and working capital facilities from their bankers. Yes?
Right.
And then at the bottom of that page, we have a column, or a box, I should say, execution of documentation.
Yes.
You see that? And it says that the continuing directors of Velocity, so that would be you and D5, would it?
That's right.
The continuing directors of Velocity will be fully authorised by the other shareholders to sign and execute all documents for the transfer of shares, including POAs for any transfer of shares of Immaculate Trade Invest Limited, in order, and I'm over the page now, to create minimal change of shareholders at the LLC level.
That's correct.
Yes. And then just further down near the bottom of I2393, the box which states bank loans obligations.
Yes.
And it says the company will ensure that the takeover of bank loans by the investor, and this will be completed in a timely manner. And then the next point down is exiting shareholders will be allowed to withdraw their personal guarantees and obligations.
That's correct.
See that? And then the company will ensure the full support of the banks, both present and future, to fulfil their plans as defined in the business plan submitted to AGIBAT.
That's correct.
And now could we go on please to I2445.
Remember this. Could you just give me a minute to make a note, please?
Of course.
Yes, I'm with you. Which page would you like me to go to?
I2445.
Two, four, four, five. Yes.
We can see that this is an agreement for a sale of shares, and it's dated November 19th, 2017. See that?
Right. That's right.
And then if you go on to the next page, 2446.
Right.
Yeah. And there's a heading, important conditions covering the arrangement. You see that?
That's correct.
Yes. And then a couple of paragraphs down, it states all the liabilities, including the bank loans standing in the name of Velocity Industries LLC, shall be taken over by the AGIBAT fund. Personal guarantees given by the existing directors/investors from Immaculate Velocity shall be replaced by appropriate documents to be provided by the AGIBAT fund. This process will be completed within 60 days of the drawdown of enhanced facilities. See that?
That's correct.
And then underneath subparagraph C, this business sale would be based on mutual trust and confidence. And AGIBAT fund will fulfill all the requirements for successful completion of the purchase of the business. See that?
I agree.
And actually, just briefly on that page, where it says this process, i.e. the transfer of personal guarantees, will be completed within 60 days of the drawdown of enhanced facilities, that takes us to around January 2018, doesn't it?
Correct.
And so according to that agreement and to the term sheet that we've just looked at, once the share sale had taken place, had been completed, the personal guarantees would be released and replaced, wouldn't they?
Yes, the only condition being that the transfer had to take place in the notary. I mean, basically the LLC company cannot be just released or based on an outside agreement. So if you could kindly go back to 2394.
Yes, I'm there.
One second, I'm just opening the relevant clause. Yeah, if you see this here, execution of documentation, which is on the end of 2392.
2392.
Yeah. So basically, you say the continuing directors will be fully authorized to sign and execute all documents for transfer of shares, including the power of attorney for any transfer of shares of a MAFU, in order to create minimal change of shareholding at the LLC level. Investors reserve the right to nominate a UAE or GCC national to be the shareholder at the LLC level, and this change will be made simultaneous to the payment of the balance consideration.
Yes.
Right. So if you take that and also look at going back to para just the previous paragraph saying binding terms.
Yes.
And it says AD 1 million will be paid at the time of signing this legally binding term sheet, but balance money within 30 days of the date of payment of advance to allow time for proper agreements to be signed and also subject to the first drawdown of the enhanced facilities. And the transfer basically meant that the transfer should take place in the Dubai Economic Department. So if this term sheet was to be to read in its entirety, 1 million immediately, within 30 days the balance consideration, assuming that all the power of attorneys, everything is in place so that the change can happen with minimal intervention at the Dubai Economic Department.
Yes, I mean, I don't think we disagree. There's nothing here which says. No,
I'm only putting this to answer your original question that if this share sale agreement was done on what date was that? I'm sorry, I've lost that reference number. What was the share sale agreement date?
19th November, I think, 17.
It was November 19th, 2017, right?
Yeah.
And you said that 60 days from that would become January
of
2018. Is that correct?
Yes.
So I'm answering that question with reference to this document that had we been able to actually finish the transfer of the company, the LLC company, by whatever means, like through power of attorneys or whatever else other supporting documents being provided, then yes, what you're saying is right, that 60 days later we would have gone to the bank, we would have spoken to them and everything would be over, right?
I understand what you're saying, Mr. Kapoor, but I mean, there's nothing in this term sheet which refers to things being done with the notary, is there? I mean, there are no, I can't see any words that you've referred to which indicate that.
I will point it out.
I mean, I appreciate that there are logistics, but the point is that the share sale agreement refers to everything being done within 60 days, doesn't it?
Yeah, see, the assumption was that they would come and give an advance. Within 30 days, they'll be ready to give the balance money. And they also wanted the transfers to take place within the, notary. So that's why I'm just explaining where it is. I'll just let me open binding terms, I think it is. No, an execution of documents it's covered. In fact, we just read that paragraph, so I'm just trying to locate that paragraph. Yes, execution of documents. The continuing directors of Velocity will be fully authorized by the other shareholders to sign and execute all documents for the transfer of shares, including any power of attorneys or any transfer of shares of Umaku, in order to create minimal change of shareholders at the LLC level. The LLC level is Limited Liability Company, which means the Dubai Economic Department. And the investors reserve the right to nominate a UAE/GCC national to be the shareholder at the LLC level. And this change will be made simultaneous to the payment of the balance consideration.
Yes.
So does that clarify your point? So you asked me that from the date of the original share sale agreement, we had committed that within 60 days, we will get the, from the first drawdown, we'll get the, guarantees released, correct?
That's what the agreement says.
Correct. And here in the term sheet, this is another condition that they had envisaged that this is a straightforward process. They'll give the 1 million advance and the balance money will be paid in order to ensure that that is exchange of the balance consideration is done at this level, when the LLC level, the company's ownership gets transferred. Right?
Yes.
So it is important to understand that unless that last mile transfer at the LLC level in the Dubai Economic Department took place, the transfer was not complete. And thereafter, it's just when the journey of trying to bring D4, D5 all in front of the notary took almost a year for them to come to the notary to sign.
We'll come on to that, Mr. Kapoor. But in the first instance, my question related to the terms of the agreement for the sale of shares. And that agreement stated, it's just what's in the agreement. That agreement stated that the process would be completed within 60 days. Now, I appreciate it may not have worked out like that, but that's what the agreement states, isn't it?
I agree. No, the reason I pointed all this out, I'm sorry to interrupt, but the reason I pointed this out is because you mentioned that from the date of the agreement, 60 days would have been January 2018. So I agree that 60 days would be in January 2018, but without this critical, what you call execution, or without this critical function of actual transfer at the Dubai Economic Department, we would not be able to comply with this term sheet. That's what I wanted to point out.
Right. And on the basis of this share sale agreement and on the basis of the binding term sheet, putting to one side the timing for a moment, once D6 to 8 had sold their shares in D1, their personal guarantees will be released, wouldn't they?
That's correct. That was the understanding.
Now, after this agreement, D6 to D8 received payment for their shares, didn't they?
That's right.
And they received it in 2 tranches.
That's correct.
And the second tranche was paid on the 13th of February 2018, wasn't it?
That's correct.
And so by the time we get to mid-February 2018, they've signed this agreement for the sale of shares. They've received all the money for the sale of the shares, haven't they?
That's correct.
And so according to that agreement, according to the agreement you've seen, at that stage, their personal guarantees should have been replaced, shouldn't they?
I understand what you're saying, and I answer in the affirmative. But my point was that without the change in the Dubai Economic Department, in fact, we requested the fund to actually release the money on the understanding that it's going to happen shortly. That means the final transfer in the Dubai Economic Department is happening today, tomorrow, because there was constant dialogue between D7 and D5 as well as D4. That is, all of us were discussing when we can do it. But thereafter, for whatever reasons, because of the non-availability of D5, this process went on getting delayed till it happened only in September 2018. So unless we had a proper document which is notarized, we could not have told the bank to change or release guarantees, because the legal ownership would have not been changed at the Dubai Economic Department.
Mr. Kapoor, you're a man of your word, aren't you?
Yeah.
And when you were having discussions with the bank later in 2018 and telling them about the change in the shareholding, that was because you wanted to keep your word, wasn't it?
That is correct.
And you explained earlier, and in fact, when you were cross-examining Mr. Manoram yesterday, that you told the bank about this change in shareholding towards the end of 2018. And in fact, this morning or earlier today, you referred to the fact that you'd given the bank a copy of the MOA, didn't you?
That's right.
Could we go, please, to J46, actually.
Yes, please.
Is this the memorandum of association which you were referring to when you said you gave an MOA to the bank?
Just one second. If the system is
Of course.
very slow. Could you just give me the reference again? Because
Of course, it starts at J46.
Right. And then which page do we get to?
But so that's just to show that it's the share sale agreement, withdrawal of a partner, insertion of a new partner, and addendum to the memorandum of association.
Yeah, one second. I'm just getting to that place. It's taking a little while to get there.
Of course.
Yeah, I got it. I got it. Yes.
Got it.
Thank you for bearing with me.
Of course. And if you look at the bottom right-hand corner, stamp, it says 25th of September 2018. Do you see that?
I can't see that.
It's quite near the page number, just at the bottom of the Arabic writing.
No.
J46?
J46, I've got.
Actually, that page is blacked out. I mean, it's probably not been uploaded completely because it stops there after defining the shareholder's name, Maku. I mean, it doesn't give a.
After the word nationality India, on the left-hand side, there's a black line across the page. There's clearly something obscured by it. Some numbers maybe, but it could be Arabic writing. I don't know.
Well, there should be. The page that I'm looking at, it states, it has Mr. Makajani's name, his nationality, his ID card number, date of birth, mobile.
Yes, towards the bottom of the page, under name, you've got Mr. Makajani.
Yes.
Nationality India. Yeah.
Yes. Yes.
Then after that is completely blanked out.
Yeah, may I suggest something, Ms. Zara? Could you actually go instead to page J57?
J what?
57, sir. 57.
Thank you.
At the bottom of the page, I think the stamp is clearly visible on this one.
Yes, that's helpful. Should be
Does that help? Does that help?
September.
Yes. Now, Mr. Kapoor, when you said earlier that you provided an MOA to the bank, was this the MOA you were referring to?
That's right.
Yes. So you told the bank about the change in shareholding because, as you agreed, you wanted to keep your word. And we can also see you doing that when you contacted Kocher and Company for help in 2019. Could you go to J292, please?
J292. Please bear with me. Yes, please. J292.
Now, we've seen this document a few times this week.
Yep.
And it's an email exchange, I suppose, between you and D7.
Right.
And around almost halfway down the page, he begins his draft note with "we have recently received." And then at the end of that paragraph, He writes, to resolve the current deadlock, BJ has discussed the matter with the legal firm, Kocher and Company, who have suggested, and then it goes on to set out their suggestions.
Correct.
Yes? And this is 30th of July 2019. So it's summer 2019 that this is taking place.
That's right.
And so again, we see you trying to make things right in order to keep to your word. Yes?
That's correct.
Because things hadn't been made right in early 2018, had they?
That's correct.
And they hadn't been made right in September 2018 either, after everyone had attended the notary either. And actually, by the time you got to September 2018, and we had everything approved by the notary, it should have been a priority to obtain the release of these personal guarantees, shouldn't it?
Which is why the amended memorandum was taken to the bank. And because the main thing we have to understand is that there were concerns about the business, there were concerns about the future projections, which is why not only the memorandum of association with the change shareholding was shared, we also shared the business plan of signing the supply chain agreement with the large multinational.
But as far as D6 to D8 are concerned, they've entered an agreement for the sale of their shares in late 2017.
That is correct.
And but we get to September 2018, they still haven't been released from the guarantees because you haven't ensured that they will be.
It's not me alone who has ensured that they will be. First step, as I explained, we had to get the changes done in the Dubai Economic Department.
Right, but
I have pointed out in my witness statements that D7 directly was also in touch with D5 to appear at the notary to put his signature so that this transaction could be completed. So first there is a delay from September 2017 till September 2018, 1 year.
Can we go to briefly to J52? In fact, if we go to J51, please.
Just bear with me, the system is a bit slow. Yes, please. Which page number?
J51.
Yes. J38. Yes, please. J51.
If you look on the left-hand column, writing in English, it refers to you and to D5, the managing directors of the company. Do you see that?
That's right.
Yes. And then in the remainder of that column, it sets out powers of the managing directors. You see that?
That's right. That's right.
And then just the third paragraph down, the bottom paragraph, in fact, I'm hoping that it will be viewable on that page. But it just says that the managing director's powers include representing the company before all third parties, including official and semi-official departments. Do you see that?
Well, after third parties is black, so I'm sorry, I can't see beyond that.
I'm puzzled as to why I don't have this issue, but perhaps I'm happy to read out the full paragraph if that would assist the court.
Yes, please.
The managing director's powers include representing the company before all third parties, including official and semi-official departments, and to sign on behalf of the company on all documents and applications form for all labour and immigration departments of the Emirates of the Dubai Municipality, Traffic Department, Department of Economic Development, Chamber of Commerce and Industry, and then it goes on to the next page where it's about airport, things like that. And then further down on J52,
Yes.
you see in bold and underlined, the following powers of managing directors shall be exercised by their directors jointly. You see that heading there. And then it provides them with powers in relation to the finances of the company. And as you've acknowledged, in this document and according to this document, it's you and D5 who are the managing directors, isn't it?
That's correct.
We go now to B151. My lord, I think you're muted.
Sorry, I'm going to intervene to ask the claimants, who I think are responsible for lodging stuff in the trial bundle. Could they try and take steps after we've finished to put a copy of J pages 1 to 238 so that it's not deleted in part at the bottom of each page? Okay.
Sure, Your sure.
Thank you.
My lord, just for your lordship's note, I'm told that, and I haven't checked this myself, but I'm told that I2949 might be an alternative page number.
I think it's important that the actual trial bundles, which contain the references that people have been taken to, should be corrected. Thank you.
Yes.
Sorry.
McLeod, could you kindly tell me which page number you would like me to go next?
B151.
D or B?
B for
Bravo.
names or something. Bravo. I'm not very good with the phonetic alphabet.
Yeah, okay. B. Could you kindly repeat the number? B for Bravo and then?
151.
Yes, please.
Now, this is headed reply of the fourth defendant, that's you, to the additional claim raised by 6th to 8th defendants. Do you see that?
Yes, please.
And at the top right-hand corner, you see the date is the 15th of July, 2021.
That's correct.
See that? And then if you just go over the page,
Yes.
we can see that it's signed and stamped by Dr. Ibrahim Havana. Yes?
Yes.
And then you've provided a statement of proof.
Right.
Yes? If you
Right.
just turn back a page to 151.
Yes.
Yes? If you look at paragraph 2, it states, instead of dealing with each averment and allegation raised against the defendant number 4 by the defendants number 6 to 8, the defendant number 4 denies all the averments and allegations raised against me by the defendants numbers 6 to 8 from paragraph 10 through to paragraph 44 through the statement of defence and additional claim. See that?
Yes.
Mr. Kapoor, do you understand what a bare denial is?
Sorry, what is it?
Perhaps I can explain it to you.
Okay.
A bare denial is where a defendant denies something but doesn't set out his or her own version of events. Now,
Okay.
this document denies the additional claim of the 6th to 8th defendant,
Right.
but it doesn't set out an alternative version of events, does it?
Yeah, it doesn't. But
It doesn't.
I had covered everything in my previous witness statements. That's the reason why I didn't want to repeat all that.
Well, you don't say that in this statement of case. You simply deny all the averments and allegations, don't you?
That's what this states.
Yes, exactly. And do you understand that that makes this statement a bare denial of the claim?
It depends on the context.
Not the legal expert.
This is the legal pleading point. It seems to me, first of all, Mr. Kapoor can't really be expected to deal with pleading points. But secondly, if his earlier documents have set out facts he relies on, don't they have to be taken into account when considering whether this is a bare denial?
My lord, this is a statement of case. There are witness statements.
I can't hear you.
It's the 6th to 8th defendant's case. We're aware of his witness statements, but it's the 6th to 8th defendant's case that his statement of case provides a bare denial of the claim against him.
Yeah,
But that's all I can put to Mr. Kapoor.
I just put a plug out. Can you give me a second? So I have a lead under my desk which I kicked, and the screen went blank.
Oh dear.
Sorry, I interrupted what you were saying.
No, my lord, that's quite all right. I was simply explaining that it's the 6th to 8th defendant's case that in this statement of case of Mr. Kapoor, there is a bare denial of the additional claim, and I was simply putting that case to Mr. Kapoor. No further questions, my lord.
Thank you very much. Mr. Kapoor, I explained at the beginning of our evidence that you had a right to re-examine yourself, but that was only really if you felt you hadn't had the opportunity of explaining your case as you went along. And I think my impression from your evidence is that you've taken the opportunity of explaining what you wanted to say in the context of the questions that have been asked. But is there anything you feel you haven't explained properly, want to go back on?
No, I think largely I was able to cover, but since questions asked for a very specific, if I may be permitted, maybe just 5 or 7 minutes, I can make a few statements which I think would be relevant.
Well, it's only if it arises out of the questions you've been asked and the answers you've given.
Yes.
It's not an option.
I may not be able to correlate which question, but you will understand from what I say.
Okay, well, if there's any objection, it'll be noted as we go along. Thank you.
First and foremost, I just want to reiterate that I came to know about all the pending criminal and other proceedings and judgments only during this trial. most importantly, I'd like to reiterate that all the events and timelines, need to be taken together, because it was like I had a cross-examination by the bank lawyer, the claimant's lawyer, sorry. I also had a deposition with the lawyer representing 2 and 5, and now with 6 and 8. So maybe a clarification from my side that instead of saying a few things now, would it be possible for me to cover the submissions in my closing arguments, where we can collate all the questions which have been put and my answers in terms of a chronology, so that things become a little more clearer? Is that permitted? I'm sorry, I can't hear you, sir. You're on mute.
I'm mute because there's a noise going on in other rooms of the House. So I'm not quite sure what you're saying. Are you wanting to explain in your evidence now something about the timelines from putting the timelines together from the various questions you've been asked?
I'll explain. If you see my deposition before the claimant's counsel, we talked about what happened with the bank and what we did with the bank. And thereafter, we did the same thing with the lawyers for D and 5, and now 6 and 8, right? Now, had there been an opportunity to re-examine myself, so to speak, I would have been able to bring out the chronology and collating all that I have said to the 3 counsels.
Yes, I see.
So if that is possible in my closing arguments, and that will be sufficient, or do I need to on record, record my submissions? That's my question, sir.
Actually, if it's going to be part of your evidence to be relied upon, I think it ought to be part of your re-examination.
Right.
But confine yourself to dealing with the precise points you want to make, rather than restate your whole case.
No, not at all. So, I think given that understanding, I'll finish it quickly. The submissions which we had with the bank, I clearly mentioned that only after September 2018, when the notarized documents from the Dubai Economic Department were available, did I go and inform the bank, because I could not have done it before that. When we went to the bank, I gave them these documents plus the additional supply chain agreement, etc., to show what is set out in the course of the future. So that means December 2018. Thereafter, if we look at the beginning of next year, we get a renewal notice, or we get a renewal advice from the bank where the limits stand reduced. And by that time, I had gone and started discussing the matter with Kocher and Company, which was May 2019. And during that period, from 2000 May to July, we were defending the matters in the Fujairah court, the civil case filed, as well as giving all the other paperwork for the entire group to Kocher and Company. And it's only at that stage when this was discovered that T1, the shareholding had not changed actually. So I just wanted to bring that timeline to re-emphasize that the bank, defendant 6 to 8, and myself, we were all under the impression that the new memorandum of association had taken effect, and we were acting accordingly. And as a basis of that new shareholding, we were representing to the bank about the new PE fund coming in, the new investment taking place, and the additional business on the table, right? So I just wanted to make sure that that is clear, because I gave this evidence at different parts to different people. In my review, all I wanted to make sure is that this timeline is clear. So it's only in December, in the month of May 2017, that we discovered, or Kocher and Company discovered, that that transaction in the notary had not happened. And that's when we made the second attempt at it through that email, which was referred to by Ms. McClone, to find a way or a solution to still, unlock the situation we were in, the state of flux we were in. So I just wanted to make sure that that timeline is clear and that's on record. So whatever evidences are there already there with my witness statement, if there's something which I have mentioned I will provide. But just wanted to cover that part in my review. Sorry, Your Lordship, you are muted again.
Is there anything else you want to say in re-examining your, or does that cover it?
I think that's all right. I think if there is anything else which comes up, I will get an opportunity when I cross-examine the other witnesses as well. So I will do it at that point of time.
Very well. Thank you. Now that concludes the your evidence, and that concludes the evidence for this session. You, Mr. Kapoor, feel free to. Well, of course, you're still a party, so you have to be here. Right.
I'll just change my hat.
Change your hat. Yeah, that's right. So, how many days does anyone think we need? I have my own view. I think we'll need 4 days. Does anyone disagree?
Sorry, my lord, did your lordship say 4 days?
Well, I think given the number of witnesses still to come, I'd have thought, well, 3 to 4 days. But if you fix 3 and finish, then it becomes a disaster. Does anyone think we should fix less than 4 days?
No, my lord, I think we would agree that 4 days would be sensible.
And will 4 days be enough? We've got the evidence of Mr. Evidence of D6, 7, and 8 before we get to experts. Sorry?
Next is D5.
Yes, I mentioned D5. D5, 6, 7, and 8. And 2 experts. At the present rate, we're not getting through more than 1 witness a day. Now, it may be quicker with D8 particularly, but I don't know. And will 4 days be enough?
Lordships, I'm instructed to say we should keep 5 at the rate we've performed this week.
Other views? McGlone, Mr. Shaheen.
My lord, I'm just taking instructions. I don't believe those instructing me have received any revised timings or estimates as to how long they expect to take with our witnesses. So I just flag that now in case it can be resolved at this juncture.
Ms. McClone, I'm given to understand that Mrs. Khan had some interaction with regards to the proposed dates, and they were looking at a span of 5 days together. And some proposed dates came from your instructing attorney's side as well, which have been considered. But I'm not sure about Mr. Shaheen. But I have instructions to state, your lordships, that we should at least keep 5 days in mind.
Perhaps I can say this, that it would be helpful that if we fix 4 days, then it takes a week, takes it out of a week, and the 5th day is almost certainly available as well. So therefore we should, it won't put it further back by fixing 5 rather than 4. And if we finish in 4 or 3, we'll all be delighted.
My lord, we can agree to that, of course.
Let's aim to do that. Now, how do you want to do this? Do you want to fix it through the registry, or do you want to try and see what, have you compared diaries at all?
My lord, I think those instructing me, certainly because for us, it's a matter of the legal team and the witnesses and various moving parts. We've indicated that we will be available between the 22nd of August and the 16th of September. I'm very sorry to the court that it's not before that, but various things have been rearranged in order to accommodate this trial, and they can't be rearranged, unfortunately. But we've indicated that that's our availability. So I present that to the court at this stage.
Hold on a second. Yes, it's not brilliant from my point of view. 22nd of August, you say, till
the 16th of September. Because those are the dates which allow for everyone who needs to be available on our side.
on your side. And have the other parties checked those dates?
Lordships, we would be available after 27th of August, right up to 16th of September.
Right.
From
Mr.
27th.
Mr. Shaheen,
I'm fine with either.
can you do this?
Yes, I can.
Sorry.
Either of those two dates suggested, I'm fine. 2 periods.
And Mr. Kapoor. My diary is difficult for the last week in August, but I could do the. Did you include the 12th week of the 12th September?
Yes, it's 20. Well, for us it was 22nd of August to 16th of September inclusive.
Right. I think I could do the week of the 12th. I'd need to confirm though. Yes. Well, look, can we provisionally fix that week for all parties? The week 12th to 16th September. Yep.
Yes, Lordships. Yes, from our end, yeah, very well.
And we hope to conclude the expert evidence as well during that time. Yep.
Yes.
And then we'll, but we're going to have written submissions or oral submissions.
Written, I believe.
I concur with Mr. Sloan on that. Written closing submissions here.
Right. Okay. Well, let's. Martha, are you there?
Yes, Judge, I'm here.
Can we? Can you confirm whether those dates are acceptable to the registry?
Yeah, the 12th of September, correct?
12th to the 16th of September.
Yes, yes, Judge.
Yes, you confirm now, or you will.
Yes,
get
Judge, I
confirmation.
confirmed that. So the registry is available to take the hearing on those dates.
Right. Okay. I just before we sign it off, I need to check with certain other commitments. But let's provisionally work on that basis, and if that's a difficulty, we'll come back to parties and try and fit it in with other days within that period. We'll work on the basis of 12th to 16th September, and I'll confirm one way or the other by the beginning of next week. All right?
I'm very grateful.
Thank you very much. We'll conclude the hearing now and enjoy your weekend. Thank you.
To your Lordships.
Have a good day.
Thank you.